allegations. And Ms. Barfoot, I'm going to ask you first to listen to Mr. Atkinson, and we're going to see what his position is, and we'll go from there. Mr. Atkinson.
Your Honor, I reviewed the video. It appears that there was she was in her driveway, was walking. That's what I saw. I never seen her get closer, and I don't know the distance because of the video, but it didn't appear that there was any issue. It just she was in her driveway and either said, "I know you're filming me," or "I know they're filming me." I believe her mother was in the yard with her, and I'm not sure. I don't know who it was directed at, but definitely was not close to. It wasn't like in the victim's face. So I reviewed it, Judge, and that's all I saw. And there may have been other stuff I missed or couldn't hear properly, but that's the only thing I've seen. And if it is a violation of law, I think it's not egregious. I don't really know how you monitor this based on the fact they're next door neighbors. And I know the case law, like I said yesterday, was somewhat in favor of trying to work it out with neighbors, but she did say something too, and it was talking about filming. So, Judge, I would ask, based on the non-egregious nature of what happened, that you just reinstate her bond on the new charge. I mean, the old charge. I'm sorry, Judge.
Give me the either of you have the case number?
Yes, Your Honor. The new case is 25561MM.
So, Mr. Mitchell, before I hear from you, let me refresh my memory of what the complaint alleges, because I think Mr. Atkinson's summary is correct. I just want to look and see what the complaint alleges. It was not, it arguably, I think that I found probable cause that was directed to the alleged victim, but more said towards her in her presence, intended to be heard by her, as opposed to going up and talking to her. And certainly it wasn't threatening. What the complaint says, alleges, oh wow, that's really, alleges, oh wow, that's really small print. Too old to read that. What the complaint says is at 12:41 on video, she said, "You're not going to believe this. Never mind, I do believe. Every time I go outside, oh, S-H-I-T, it's ridiculous." And then at 13:13, she said, "You're not going to believe this. Never mind, I do believe. Never mind, I do believe it. It's ridiculous. I know you're recording me. That's okay. I'm not doing anything wrong." So my question for law enforcement before I signed the warrant was she on the phone or was she talking to someone else? And law enforcement's response was to send me a video that I didn't ask for, but watch 15 seconds of the video clip, which I did watch, and there's no one else on the video. Now, Mr. Atkinson may be correct. Maybe someone else off video. I have no idea, but it does not appear she's holding a phone. So that was the basis for me finding probable cause for the new crime and signing the arrest warrant. But as I mentioned yesterday, due to the lack of egregious nature, I was hesitant to revoke her bond. Mr. Mitchell, what's your position?
Your Honor, I did want to say that I also reviewed the video yesterday, and there was also an additional part, I guess, in response to Mr. Atkinson saying that he believes that this was directed at her mother. I listened to the video also, and I heard Ms. Barfoot say at one point, "stupid idiot," also. So I don't know if she was directing that at her mother.
So what are you asking me to do? Are you asking me, let's start with the bond issue. Now that you've had a chance, I'm thinking your email that you sent to me and Mr. Atkinson, you said you had spoken with the alleged victim.
Yes.
So are you asking me to revoke the bond or not?
If she does not want to accept the offer for 1-year probation in case number 25464MM with the agreement that we dismiss this new case, then yes, I am asking that we revoke the bond in that case.
So Mr. Atkinson, there's no plea agreement reached. Is that correct, sir?
That's correct at this point in time, Judge. Judge, may I correct one thing if I misspoke?
Sure. Sure.
All I said was, and if I misspoke, I apologize. I believe her mother was in the yard with her. I don't know who it was directed at. I just know her mother was in the yard with her.
I may have misspoke. My apologies also.
So what's in the complaint that's most concerning is she has an injunction. She's been to court. She's been accused of violating an injunction. She's ordered again, no contact. And then allegedly on video she supposedly says, I know you're recording me. That's okay. I'm not doing anything wrong. That portion would appear to be directed to the alleged victim. Now, the rest of it, you're not going to believe this. Never mind. I do believe it every time. It's ridiculous. That could she be talking to herself or talking to someone else.
Yeah.
But I know you're recording me seems to be directed to the alleged victim. And that's, if that happened, that's certainly probable cause for violation of injunction. So my question, Mr. Mitchell, is did you get into the circumstances surrounding the recording? Is this like a ring system that's being recorded on? Is the alleged victim got a phone in her hand? Is this a 24-hour recording? Where does the recording come from?
It looks like it comes from her cell phone by the looks of it.
Or when the alleged victim goes outside, she has a cell phone recording every time she goes outside? I don't understand.
That's the way I see it.
Yes, sir.
Judge, what I understood happened is my client was outside working in her garden. And then the victim came out to, I think, put up a wind chime or something like that and had her phone recording. So after my client already went outside.
All right. Don't say anything. Your attorney don't want you to say anything to hurt yourself. Mr. Mitchell, anything else from the state?
No, Your Honor.
Mr. Axon, anything?
No, sir, Judge.
Okay, I'm not comfortable holding someone in jail with no bond for that statement. Okay, I just don't know that that's something I'm comfortable doing, ma'am. What I am going to do is I'm going to stress to you the following. There is an active injunction, and I would suggest to you, you say absolutely nothing to this person. If
Yes,
she's
sir.
outside, don't say anything towards her. You talk to whoever you want other than her, but don't say anything to her, and don't say anything. I wouldn't even say anything about her, because she may interpret that as being directed to her. You want to talk to your mother or anybody else, that's your right. But you certainly can't say, and this is what you're accused of. I'm not saying you did this. I'm saying this is what you're accused of saying is something directed to her. I know you're recording me. That's okay. So the reason I'm going to give you the opportunity to post bond is there was no threat of violence. You spent a couple of days in jail, and I just need you to understand no contact, and the injunction issued by whatever judge issued it, it wasn't me, means no contact, nothing at all directed to her in any way. If that happens again, I will have no conclusion, but to reach, the only thing I can do is assume it was intentional. I'm kind of giving you the benefit of the doubt in this situation for the reasons I already said, but
Yes, sir.
nothing at all that can be interpreted. And she's got the right to record you. You've got the right to record her in public. So that's
Yes, sir.
strange, but it is what it is. It's unique, I should say.
My
Mr. Axon,
husband is
any other
building a fence, privacy
Okay.
fence.
Let me see if your attorney has any other suggestions, because Mr. Axon wants to keep you out of trouble, probably as bad than I do. Mr.
Judge.
Axon, any other questions or instructions for your client?
No, Judge, I would ask and instruct her to come to my office as soon as if she posts a bond, come to my office. We will go through it in detail, Miss Barfoot, one more time.
Thank you.
And we'll talk
Yes,
about
sir.
the fence. And if there's a fence going up, Judge, that may solve a lot of problems. So
let's say-
It's already $700 in it already.
Fences make good neighbors.
that's
Yes,
right.
I do. And
All right, let me see if Mr. Mitchell has anything
not at this time, Your
as far
Honor.
as court date.
I think we
Tell me
can
about
set her for the December case management docket.
Mr. Axon, is it your intent to represent her on both charges, sir?
Yes, sir, Judge, we're going to do that.
So she's probably already set for a case management docket on the first case. So we'll just add the second case to that same date, whatever that is. And Mr. Axon will get a notice, you'll get a notice. So Ms. Barfoot, make sure you follow Mr. Atkinson's instructions. You have the bond I set yesterday in the new case. I'm not revoking your bond, as I've explained. You post the bond on the new case, you'll be released. Do you have any questions, ma'am?
No, sir. Thank you very much, Your Honor.
Ms.
and
Barfoot,
Mr.
come to my
Axon.
office as soon as you're released, okay? Please, okay?
Yes, sir.
All right.
Yes, sir.
Thank you.
I'll be there.
Thank
Thank you
Mr.
all.
Axon.
Appreciate it.
All right, so we do have friends or family here on at least one case. That's Jan Pravat. So let me see Ms. Pravat next, please. Ms. Pravat, good morning. Ms. Pravat, my notes, your son and your daughter are both in the courtroom. Ms. Pravat, you've been accused of 3 charges. Discharging a firearm over an occupied dwelling. What that statute is titled is discharging a firearm in public or on residential property. There is one little subsection that says over. an occupied dwelling. I don't know, there's probable cause she discharged a firearm over a dwelling. She allegedly shot in the air. There's certainly probable cause that she discharged a firearm in public or residential property, which is what the statute's called. The second charge is improper exhibition of a firearm. That's another first-degree misdemeanor. The third charge is use of a firearm while under the influence of alcohol. So there's probable cause for 3 charges, all of which are misdemeanors. I'm going to appoint the public defender's officer to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney, and then we'll listen to the state. Mr. McDaniel?
Your Honor, we just asked for a reasonable release option, take into account that neighbors are having problems. You know, I don't think the officers put everything in the complaint. I don't know if they put in there that she was on her front porch when she did this. You know, they clearly do not like each other and are arguing and bickering, and the neighbor comes over in fighting mode to her residence with someone else with her to essentially beat her butt. You know,
Is that an allegation in the complaint?
it's not, they didn't put any of that in the
Okay.
complaint. I don't think any of that was in the complaint, that it was happened on her porch, you know what I mean?
And the
So I
complaint
just
says the
think
neighbor
that-
was in her vehicle.
What's that now?
The neighbor's version is she was in her vehicle when it happened.
Okay, so
That's the neighbor's
that's
version.
neighbor's
I don't know
version.
Mr. Pratt's
Yeah, I
version.
was thinking, yeah, she told me it was, you know.
And it may be.
yeah.
It may.
No,
No.
sir, I wasn't on, I wasn't in my
Don't
vehicle.
talk, ma'am. I'm telling you a story, okay?
No, no, I'm
So-
trying, let me clarify. The complaint says the neighbor was in the neighbor's vehicle, not Ms. Pratt was in the vehicle. It doesn't say where Ms. Pratt was at, but go ahead, please.
Yeah, and that, you know, that's, you know, keep that in mind, Your Honor, that
Okay.
she's alleging that and she has witness there also. She tells me that she was, you know, coming back to her property to the front porch and has done this before in the past in fighting modes, and just take that into consideration. And also, you know, I know the officer puts in there, and I just happen to know my observations this morning, and I know people that have really high blood pressure and other issues. Her eyes are bloodshot red right now. I'm not saying the officer's mistakenly about the alcohol. I don't even know, but I just know her eyes are bloodshot red right now. And I don't know if that has to do with high blood pressure and other issues, you know,
Okay.
instead of alcohol, because she was just driving. I kind of question when she was on alcohol.
Thank you. Mr. Mitchell?
We're in agreement to a reasonable bond under the circumstances and treating the discharging firearm as in public charge instead of over an occupied dwelling.
Ms. Pratt, the criminal history I've got shows no prior criminal history. Is that accurate, ma'am?
Yes, ma'am, I've never been in trouble.
Ms. Pratt, I'm not going to give you conditional release because the allegations of a firearm are very concerning, but I'm going to set you a lower bond than I might normally set because you have no prior criminal history and because these 3 charges are all very similar to each other. The officer's chosen to charge 3 charges, and I think there's probable cause for 3 charges, but the state certainly may decide to charge 1 or 2 or all 3. That'll be their call.
I forgot one other thing. We would also include a condition of no possession of firearms and no possession or consumption of alcohol. You were probably going to do that, but I just want to put that on record.
Thank you. So, Ms. Pratt, your bond's going to be $2,500 on the first charge, discharging a firearm in public, and $1,000 on the other 2 charges. Your total bond is $4,500 cash or surety. You have a condition that you not possess any firearms while this case is pending. You can't have access to firearms. You also cannot possess or consume alcoholic beverages because there is an allegation. Other than bloodshot eyes, there's other indications the officer saw that alcohol, that your abilities were impaired, which is an element of one of the charges. So you cannot possess or consume alcohol. You can have no contact with Ms. Nichols, the alleged victim. What that means is this. Her bond is $4,500 cash or surety. Cash or surety means you don't have to come up with all the money. She doesn't have to come up with all the money, and she can go through a bondsman. If you go through a bondsman, and if they charge you the normal 10%, it would cost you $450 to get out of jail. If you pay all $450, all $4,500, you'll get it all back. If you go through a bondsman, what they charge you is their fee. And that 10% is sometimes negotiated by a bondsman. So those are the conditions. She has no firearms, no alcohol, no contact with this person at all. She sees her walking across the street, she ignores her. That's no contact. It's that simple. But if you post a bond for her, she'll be released. Lastly, we're going to give her notice for her next court date, which would be December 2nd. December 1st at 9 a.m. will be your court date. Ms. Pratt, I'm going to ask the jail to give you that notice after first appearance. So your daughter and son are here, and I'm assuming they're going to be trying to post bond for her. They said they're going to be trying to post bond this morning, ma'am. And if they post bond for you, you'll be released. Just make sure you have no contact with this person, follow those other rules, and be in court on the December 1st at 9 a.m. Ms. Pratt, do you have any questions?
Yes, I do.
Okay.
I had my door. I could not, that
Ms.
door.
Pravat,
wouldn't
don't
lock.
talk about, remember, I asked you, don't talk about the case, okay? That's going to go to a jury, not today, ma'am. Just remember also, just as a word of advice, you heard that last case, do not do not talk to your neighbor. You need to turn the other way and go another direction, because if there's allegation y'all are talking and arguing out there, you're going to be sitting in jail. I want you to be clear about that, okay? So, Ms. Pravat, just talk to your attorney in private. I don't think you have any questions. I think you want to tell your side of it, which is fine. It's just, this is not the time to do that. The time to do that is after you talk to attorney in private. Does the family have any questions? All right, Ms. Pravat, wish you the best, ma'am.
Thanks.
Next case, we have no one else here on first appearance case at the jail. So we'll go back to take the first two, Brittany Parker and Charles Parsons. Yes, ma'am, absolutely. Thank y'all for coming. Let me see Brittany Parker and Charles Parsons. Ms. Parker, Mr. Parsons, good morning. I'm seeing you at the same time because your cases are identical for first appearance purposes. Each of you are accused of violating in terms of your state probation, and in each case, the circuit judge has signed a no bond warrant. What that means, I'm going to go ahead and get you arraigned this morning because I want to get you a lawyer appointed if that's what you're asking for, and I can do that once an affidavit's been filed, as it has in your case. Ms. Parker, would you like to have an attorney appointed to represent you?
Yes.
All right, Mr. Parsons, same question.
Yes, sir.
I'm going to appoint the Public Defender's Office of the 14th Circuit to represent each of you. Listen to your attorney for today, Mr. McDaniel, and then we'll see if you have any questions in just a moment.
Your Honor, we're going to plead not guilty. He has to set this in the December 4th pretrial docket, and I advised them both, Mr. Green, to come by and talk to them prior to that hearing.
December 4th, Mr. Mitchell, anything?
No, Your Honor.
Ms. Parker, do you have any questions, ma'am?
No.
No questions? Have a good day. Mr. Green will see you before your court date. Mr. Parsons, any questions?
Yes, sir. I have a drug problem. That's why I'm here. I filled a UA and I have a drug problem.
So, Mr. Parsons, what I would suggest is talk to your attorney about that. I don't really know much about your history in this case,
Yeah.
Mr. Parsons, but if it's something that you're interested in, and if the state agrees, and if most importantly, the judge agrees, that may be something they can address in a sentence, such as some type of inpatient treatment. But there are a lot of factors involved, such as have you ever been before? What's your overall criminal history? How long have you been on supervision? There's a lot of factors, but talk to your attorney about that in private first, okay?
Right.
Have a good day, sir.
It's likely it's going to be my case, so I'll take that into account.
Thank you. Thank you, Mr. Mitchell. Laura Raffield. Ms. Raffield, good morning again. I saw you yesterday for some other charges. After first appearance yesterday, you've been accused of 3 new charges. They are trafficking in methamphetamine, smuggling, which is the introduction of contraband into a county detention facility, and tampering with evidence. There is probable cause for these charges, ma'am. I'm going to ask that you listen to the attorneys before I address your bond status. Mr. Mitchell, anything from the state?
Judge, we would just ask that you move to revoke her bond in the case that she was first appeared for yesterday. I don't know if it's been assigned a case number yet.
Let's see if do you have a case number already? Okay, so before I hear from Mr. McDaniel, I texted y'all this morning and said if that's something the state's going to be asking for, put some thought into it. So tell me, the question is, did any of these charges allegedly occur after the bond was set? So Mr. Mitchell, let me hear from you on that.
Based on what I could see in the complaint, I think definitely the tampering happened after the bond was set, before she was taken to Jackson Hospital. And there is arguments, I can't remember what we were discussing or what the terminology was, that it was a continuing charge involving the trafficking case. And
There's no trafficking.
ma'am,
Don't speak, ma'am.
and I think it's also a continuing charge for smuggling the contraband. So I understand that there's continuing circumstances when it comes to the trafficking and smuggling contraband. But the state would argue that the tampering is definitely a new charge that happened after bond was set. So based on that, that's why we petitioned that her bond be revoked in 25545 CF.
Let me read that statute, Mr. McDaniel, before I hear from you.
Yes, sir.
I'm concerned about 893.02 subsection 4. That can't be right. I think it's going to be 951.22. So there's a different statute for correctional facilities, state correctional facilities and county correctional facilities. So the county one, which is what officers charged here, says it's unlawful, except through lawful channels, to introduce into or possess upon the grounds of any county detention facility. Okay, so Mr. McDaniel, would you like to be heard, sir?
Sergeant,
Your Honor, I would just argue that, this is a continuation of the same crime. Essentially, she was taken into custody while she was at DOC. She was in custody, has been in custody since that point in time. So whatever crime also happened at DOC, this could easily always a continuation of the same crime, including trying to hide it. That was all being done at the same time. They didn't find it until, essentially right after first appearance yesterday. But it is, she could be charged, I think the exact same charge crimes with the DOC also, because she was taken into custody and she never had a chance to put those things inside of her body. I think the state can easily make an argument that these are all the same crimes in that same felony case. I don't know if she's going to be a post bond, but I would just argue that it, based on the circumstances of this being one continuous crime that continued on through the process of yesterday, that, revoking her bond is, holding her without bond is probably a very high, extreme kind of position to take on a case like that, where it's just the same crime that's been continuing.
Thank you. So Sergeant Glazer, are you in the room out there?
Yes, sir.
Can you come up to the microphone? So the chief called me before this all happened and was asking, was it possible to get a search warrant? And I explained to them the search warrant process, how it all worked. They need to contact law enforcement and so forth. But what my understanding was, the first incident happened, she comes to jail. An officer thinks she sees something on her body, but Miss Raffield supposedly wouldn't consent to a search. She goes to the hospital one time. At the hospital, she refuses medical treatment. So they take her back to jail. And then that's when the chief calls me. I said, well, here's how a search warrant works, because this is a very unusual situation for the jail. Y'all don't deal with search warrants very often. So you might be able to get inside of her body, but here's the process. Here's the burden of proof. Here's how a search warrant process works. I don't hear anything else. We first appeared her yesterday, and then after first appearance yesterday is when this current case happens, and the complaint says she essentially comes to y'all and says, I do have something inside of my person, and I can't get it out. Is that your understanding of the timeline, Sergeant?
Yes, sir.
Okay. And then the complaint alleges that she was able to remove some of the methamphetamine and flush them. Supposedly she said this. Just a second, ma'am. The complaint says she told him she removed some of the methamphetamine and flushed it, but she couldn't get at least one package out. And that's when they went to the hospital. And that hospital yesterday, the second trip to the hospital, they successfully removed the methamphetamine. Is that the timeline, as far as you understand it, the allegations?
As far as I know, yes, sir.
So, Mr. Mitchell, that the phone call about the search warrant may have brought something else to the state or the defense's mind, and it's irrelevant other than she made 2 trips to the hospital, not 1. That's at least my understanding of the timeline. Mr. Mitchell, anything else from the state knowing that additional information?
Nothing additional, Your Honor.
And the law, I never saw a search warrant application, so I'm going to go out on a limb and assume they didn't apply for one, because I would have seen it. Mr. McDaniel, anything else?
Nothing, just, Your Honor, that it's just a continuation. Even the other part of the crime happened prior to first appearance. She continued the crime, but all of these things happen. They're all the exact same crime, Your Honor. We just asked that she set a bond on these charges, and we'll probably see her at jail arraignment, I suspect. After talking to her.
Ms. Raffield, it appears to me that based upon the timeline, the allegations are you had that substance inside your body at the time I first appeared you yesterday, and then after first appearance, became worried about not being able to get it out. Told law enforcement or told, I'm just telling you the timeline, ma'am. I don't want you to call me because I don't want you to hurt yourself. Okay. I'm not trying to cut you off. I just don't want you to hurt yourself. And that's what I'm afraid is going to happen if you talk about the allegations against you. And and then the crime is possessing, arguably, there's probable cause that you committed the crime of possessing after I set the bond. But it's just a weird timeline. What I'm going to do is I'm going to set you a higher bond than normal because I think you were committing a crime probably when I first appeared to you yesterday. So I'm not going to revoke a bond, but I'm going to set a bond at $100,000 on this trafficking and $50,000 on the smuggling and $25,000 on the contraband. So your bond today is $175,000 in addition to whatever it was yesterday. Before, ma'am, because of the timeline, as I understand it, but I'm not comfortable revoking her bond because of the argument Mr. McDaniels made that it's a continuing crime. So you've got that bond, ma'am. Anytime your bond changes, you have the right to use the phone, ma'am, to contact friends or family. You
They
can
never
certainly
let
do
me
that.
use it. They
Yes,
never
ma'am.
let me use it yesterday.
Okay,
I
I'll get to
never-
that in
yeah.
just a second. Just a second. I'll come back to that. You do have a condition of random urinalysis, and you're also going to have the same court date you were given yesterday, which is December the second at 8:30. So you were saying you weren't able to use the phone yesterday?
I wasn't able to use the phone, and really, I just want a speedy trial so y'all can go ahead and sentence me and send me on.
Okay.
Can
Sergeant?
we do that?
No, I can't do that. I'm just the first appearance judge. Sergeant, what do you know about the phone use?
Well, she's been on suicide watch, so she doesn't have access. She's in the process of talking to life management right now, so as long as she clears her, then she'll be able to use the phone.
Can you lose your right to contact someone for purposes of posting bond just because you're on suicide watch?
I don't think so. And I think it was just because of all the stuff that was going on yesterday. My
cannot.
expectation is the jail's going to let her use the phone this morning to try to post bond. I don't think she's going to be able to post bond, but I think that the jail will be letting her use the phone for posting bond, letting know family members where she's.
Sarge, what I want to instruct the jail to do is contact the county attorney or the county manager, county administrator. I have no idea, but that rings of me if a jail says they're on suicide watch, therefore they lose their constitutional right to make the phone call. That just doesn't feel right. I don't know if it's appropriate or not, but my suggestion is y'all contact the county attorney and ask them to research that issue. Mr. Mitchell, I'm gonna ask the state to research it also, because I just, that smells like it may be a violation of her constitutional rights. So just, I don't want y'all to get accused of violating her rights. Certainly she needs to use the phone this morning. Ma'am, I wish you the best.
Okay, so he reviews court. When we see him later, we will decide what the appropriate bond should be, but I made note of what you're requesting.
Thank you, Your Honor.
Let me just review for probable cause. So you had a cylindrical tube.
Yes, like a stake, a metal stake.
What did he hit the victim with that he's charged with aggravated battery?
It's like a metal stake, kind of like a nail rod, but large metal nail rod or steel.
A large metal nail rod for what?
It's either out of steel or metal.
Oh.
Like a piece of
How big is it?
rebar? Can you describe it a little as best you can?
It would be like basically like a maybe 2 to 3 foot, 3-foot nail, like a nail rod, like a metal rod,
Oh, okay.
but with a sharp corner, sharp edge.
Ms. Corey, do you have any questions for the officer? No, Judge, thank you. So I'll find probable cause on F-25-252. 51 for aggravated battery. Second. Which one, Your Honor? I'm on F, just finding probable cause F-25-25251. I'm just looking for the drug paraphernalia.
I also find no probable cause for the paraphernalia.
It said that a cylindrical tube. So it looks like it was a pipe. Do you know if there's any residue on the pipe, officer?
I wasn't there at that. I was
Okay.
dealing with the victim. I was not
Okay.
there.
No problem.
One minute. Probable cause though for the falsely after arrest. Probable cause for 1 and 3. Reset it for the afternoon.
Thank you, Your Honor.
And then we have the other cases. Mr. Alexander, what do you hear on which one? Both of these others?
Yes, ma'am. I am not sure if they both stem from the same A form. Devin Alexander on behalf of victim CBS. I am not sure if they stem from the same A form, but there is one A form that was incorrectly charged. It was only charged with one petty theft, 2 or more convictions, and it should have been 2. There is probable cause, and there are 2 counts on.
Judge, who are you calling? I'm still on Zachariah Spine Skinner for his other 2 cases. I have the victim representative from CVS coming in to tell me what he wants to do on behalf of his client, what he's asking for.
Yes, ma'am. So I just wanted to point that out. But he, in this A form that I received last night from the officers, on 2 different occasions, he stole, I believe, soda streams, which are 2 pretty expensive items. And I just wanted to note, around this time of year, the managers in these stores are judged heavily on what they can sell, what is stolen from them, which might not be fair, but that is the nature of the beast. So it is more impactful than it may seem on the A form. So we do request, obviously, a stay away order, and we'll defer to Ms. F on what she believes that the bond should be, but we would ask that it's elevated just then higher than standard.
Thank you. Okay, he's not here,
Okay.
so I'll reset it for the afternoon.
Yes, Your Honor. Thank you so much.
There's probable cause in F25-25271 for petty theft or more convictions. Let me take the other case. So it's, what is it? Oh, Savage Xfinity. Sorry, I got it. All right, so the other case, there is probable cause for also petty theft. 1 second. Well, it says new prior convictions, and they give a case number. That's good enough for me. Reset it for the afternoon, all 3 cases.
I'd be excused, Your Honor.
Your excuse, thank you.
Thank you, Your Honor. Have a good week.
You too. Okay, this now. This is Yohan Lopez, page 4. Yohan Lopez, private attorney. Can you raise your hand? Who is it? Thank you. I got 2 lawyers. Oh, and the bondsman. You got a bondsman here. Thank you for the bondsman raising your hand.
Spanish interpreter, please.
Spanish. Good morning, sir. You were arrested for burglary to an unoccupied conveyance. I'm sorry, burglary to an unoccupied dwelling, dealing in stolen property, grand theft, a 2nd-degree felony, and unlawful use of a communications device.
Good morning, Your Honor.
Muy buenos días, usted enfrenta varios cargos, solo no tiene que ver con hurto mayor, tiene que ver con ingreso ilícito a una vivienda desocupada y también por tenencia ilícita de un dispositivo de comunicaciones.
And also criminal mischief.
Y también por daño en propiedad, fechoría.
Your attorney is present. Can you state your name for the record, please?
Attorney Arturo Taquechel on his behalf, Your Honor. Good morning.
Se acaba de presentar el abogado que lo está representando.
Good morning. I also have in court, are you police officers?
Yes, detectives.
Detective, please raise your right hand to be sworn. Do you swear or affirm, there's 2 detectives. Do you swear or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
I do.
Está también presente el oficial que acaba de presentar juramento.
All right, detectives, I guess I'll start with you. What is your name, please?
Detective Jonathan Gross.
Okay. And who are you?
Detective Juan Segovia. I'm the sheriff.
Thank you.
Se acaban de presentar 2 detectives que están ahí presentes en el juzgado.
All right, so give me a moment to review this arrest affidavit for probable cause. So this is an incident that goes back to September 12th of 2025.
Este incidente se remonta al 12 de septiembre del 2025.
Okay, I had a chance to review the arrest affidavit. Detective Grossman, what do you want to tell us?
Acabo de leer el informe del arresto, dice la juez, y le pregunto al detective qué quisiera el detective decir.
We're just here in the event the state needed anything.
Estamos acá solamente en caso de que la fiscalía necesite algo.
What were the damages to the amount of damages to the victim's apartment? There's no amount of damage to the.
My understanding.
La juez pregunta a la fiscalía cuál es la cantidad de daños que sufrió el apartamento de la víctima.
It was a door lock. I believe they estimated it on the chart between 200 and less than 1,000.
Okay.
I'm sorry for the interrupt, but what was that again, please?
That it was estimated between 200 but less than 1,000. I think it's what.
Fue entre 2,000, entre 200 y 2,000.
There was no value listed in the body, the stored narrative.
I'm sorry. That's my understanding.
Okay. All right, so you don't. All right, any questions for the detectives?
No questions, just argument, Judge, whenever the court's ready.
La fiscal no tiene preguntas, solamente un argumento.
And Mr. Takashil, did you have any questions for the two
I do.
deputies?
I do not, Your Honor.
El abogado tampoco tiene preguntas para el detective.
All right, so,
Judge,
sir, 1 second, sir, you are ordered to stay away from the victims. You want the, what's the victim's initials? State.
victim's initials are ADH.
Stay away from the alleged victim whose initials are ADH.
Tiene que mantenerse alejado, le ordena a la juez, de la víctima cuyas iniciales son ADH.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
Puede contactar a esta víctima ni directa ni indirectamente, tampoco en persona, ni por teléfono, ni a través de terceros, ni por escrito.
No contact with the victim through social media or other electronic means.
No podrá contactar a la víctima a través de las redes sociales ni por ningún otro medio electrónico.
And you must stay at least 500 feet away from the victim's home, school, and place of employment at all times.
Y en todo momento se tendrá que mantener alejado por lo menos a 500 pies de donde la víctima vive, trabaja o estudia.
And you must stay away from his victim's residence at 1032 Northwest 87th Avenue in Miami, Florida.
Y en todo momento tendrá que mantenerse alejado de la casa de la víctima que queda en el 1037 de la 82 de la Georgia 87th Avenue, right?
87th Avenue, yes.
Thank you, Honor. De la avenida 87 de Miami, Florida.
Okay. Do you understand the stay away order?
Señor, ¿usted entiende la orden de alejamiento?
All right. I had one
Judge, the
question.
state's requesting an increased bond on this case. It looks like they cased the residence and burglarized the house, a house that had appears to be, very expensive jewelry.
Really? I don't see a
I
value.
don't know
for
if
the jewelry.
it talks about diamond. It talks about diamond jewelry and a
Where does
Rolex.
it say the value of the jewelry on here? I don't see it.
So
It
detectives.
says Rolex watches. I don't know. How do I know it's real? Is it Detective Segovia?
Yes, Your
What's the
Honor.
value of the jewelry that was the victim?
Your Honor, I do not know. We're assisting the Midwest District. What I wanted to tell you was that this is a very well organized and sophisticated group of burglars that have been terrorizing the area. The last time this group was taken down, about approximately 2 years ago, the percentage of burglaries that went down in Midwest District for Miami-Dade Sheriff's Office was 68% just from taking this group down. 2 years later.
Esta detective, señoría, primero que todo, la fiscal está pidiendo una fianza elevada debido a la cantidad sustancial de joyas y relojes que sustrajeron de la vivienda. El detective dice, señoría, individuo pertenece a una banda organizada que por los últimos 2 años ha venido aterrorizando el sector con
What can you call up Officer Mazza who wrote and find out the value? We'll pass the case for a minute. We need to find out the value of the merchandise that was taken.
para pasar el caso porque la jueza está pidiendo que se dé un desglose de la cantidad del avalúo de las joyas.
Have a seat. We'll be with you in a moment.
Tome asiento, van a volver a llamar su caso.
Detectives are gonna call?
What?
I wanted to see if I needed to call or if the detectives are gonna call.
You what?
I wanted to
You're
see if
following up with detective who wrote this.
Excellent. Thank you, Judge.
All right, next we have Menachem Paris, page 5, private attorney. So, here we go. Mr. Takashel, I'm putting you as an attendee since you're not putting off your camera. When you come here and I'm not on your case, you need to turn off your camera. But since you're not doing it,
Your Honor wants me to turn it off?
Until the case is recalled.
You need to know Zoom etiquette here. Turn off your camera until your case is.
Your Honor, that's for Paris, correct? I don't have that person as a.
Paris isn't here yet.
Oh,
Hi, Mr.
not
Neighbor.
Maber on behalf of Paris, so I'll
He's
wait.
not here yet. Can you get him so we can, oh, the one from yesterday.
The third
They
roommate
had
looks
3
like.
boys living in his house doing this. That's terrible.
Yes, Your Honor.
I'll pass the case. Out of turns for correction, sorry. Next, we have Gian Crespo, page 20. Also, there's family here for some cases. I'll try and get those. Did you get the value yet?
Yes.
When you're ready, I'm recalling Johan Lopez. They got the value. So bring in whoever you got. I'm out of control today with the organization. Let's be happy it's Friday. I got to pass your case. Oh, he's here now. All right, Mr. Mayberger, client's here.
Good morning, Your Honor.
Mr. Harris, good morning. You were arrested for trafficking in amphetamines, trafficking. This is Mr. Crespo. Oh, it's Mr. Crespo. I'm sorry.
62 on the calendar on page 20.
Pardon me. Oh, no. Mr. Crespo, you were arrested for escape, tampering with an electronic monitoring device, and criminal mischief. I will appoint the public defender's office for you. So count 1, the escape. What do you want? An ROR or a dollar?
Dollar.
Count 1 is $1. Count 2 is $2,000. Count 3 is $500. Have a nice day.
Welcome again, everybody. Happy Super Friday. It is the Courtroom Files. We are live. We are watching Judge Glazer kind of walk the line on a possible Friday meltdown already. We'll see how it goes. We'll stick with her for a few more minutes as other courts come online.
Okay. With Spanish interpreter. So, sir, we're back. The detectives or deputies walk back in the courtroom. Detective Grossman, hello, good morning.
Ya, señor, su caso lo están llamando de regreso. Aquí están los detectives presentes en la sala de juicio.
After conferring with the primary lead on the burglary case, it's estimated that the value of the items that were stolen was $30,000.
Se estima que el avalúo, la cuantía de los artículos robados asciende a los $30,000.
Okay, thank you.
That would make it a grand theft second.
What?
That would make it a grand theft second.
All right, Mr. Takashel, do you have any argument regarding your client and the bond this court should set?
No, Judge, I'd just like to request a standard bond be set and posted by him. He's not a risk of flight nor a danger to the community.
La juez le pregunta al abogado si tiene algún argumento. Él dice que no, él está pidiendo simplemente la fianza estándar. El abogado alega que su representado no representa riesgo de fuga y no representa riesgo para la comunidad.
He had numerous arrests back in 2013 for burglaries and grand theft and criminal mischief, and it looks like he got 3 years in prison.
That's correct, Your Honor.
Bueno, desde el 2013, este acusado ya fue arrestado varias veces por ingresos ilícitos a viviendas y también por hurto mayor. El abogado confirma esa información.
And then there's, he just got off of probation earlier this year. It looks like grand theft of a vehicle, resisting without, and offenses against computer users.
De hecho, ya había terminado libertad probatoria a comienzos de este año por hurto mayor de un vehículo y también por resistirse sin violencia.
Corrections, does he have any immigration holds or no?
No, he does not.
No, Judge.
no tiene orden de retención migratoria.
All right.
So the state's requesting a $50,000 bond on the burglary based upon these facts, as well as the defendant's criminal history.
Entonces, a la luz de estos hechos y del historial criminal de este acusado, la fiscalía está pidiendo una fianza de $50,000 por el delito de ingreso ilícito.
Also requesting Nebia and house arrest.
Y también una audiencia tipo Nevia y arresto domiciliario.
It's overkill, Your Honor. Once again, I request Your Honor set a standard bond, and that would be sufficient to guarantee his presence in court.
El abogado dice que no amerita tal cantidad, que la fianza estándar es suficiente y que para que garantice que regrese a comparecer por estos cargos.
He's a signal 100. I'm setting a bond count 1 burglary to the unoccupied dwelling is $50,000 bond. Count 2 dealing in stolen property will be $2,500. Count 3 grand theft. I'm splitting 2 and 3. You can't be convicted of both. $5,000.
Entonces, por el primer cargo, por ingreso ilícito, $50,000 de fianza. Por el segundo, por comercializar con mercancía robada, $2,500. Por el tercero y el cuarto, $5,000.
Count 4 unlawful. Count 4 unlawful use of a communications device is a 3rd-degree felony. That's $2,500. And count 5 criminal mischief, no value, $150.
Por el cuarto son $2,500 y por el quinto, Your Honor, for the interpreter for the fifth one, how much is it again, please?
$150 for count 5.
Got it. Thank you, Judge. Y $150 por el número 5.
Also, it's house arrest with a GPS monitor, level 3 house arrest.
La juez le impone también arresto domiciliario nivel 3.
And no curfew and a Nebia requirement. You have to show the money used to post your bond is from a legitimate source of funds.
Se le impone también un requisito Navia para demostrar que los fondos que va a usar para pagar esta fianza vienen de un fondo legítimo.
Was you gonna do the curfew? It looks like he.
No, I didn't do a curfew. He's doing this during the day.
Curfew.
He's not, Judge.
He's not? Is it during the curfew or
So
no?
the victims said at 9:30 in the morning. Oh, hold on. Okay, you're right. He did.
It's a curfew, Judge. He's a grown man.
Well, that's to make sure there's no crime.
I mean,
out and about. But
we've already raised the standard bond. We've already put an ankle bracelet on him. We've,
I didn't give him a curfew. I listen. Didn't have a monitor. That place where he sold it, did they sell the jewelry or they own that jewelry store in the Seabold?
So he would, the items were stolen and then he would go to the Seabold building and offload the.
Oh, okay. Have a nice day. Thank you, Mr. Tackett. Shall you have a good lawyer?
Okay, that's a total of $60,000. The bond. 60,000, 150.
Right. Okay, thank you.
And it's a level 3 house arrest.
Level
correct?
3, it's just gonna wear a monitor. We're gonna know where he is.
Right, but it's rolling. Very good. Thank you.
También le pondrán un grillete electrónico para saber dónde está.
Okay, now out of turn for corrections, unless you have Mr. Parrish yet?
Yes, we do.
Oh, bring in Mr. Paris. Okay, bye, Mr. Paris. He's on page 5. I don't think we'll make it anywhere this afternoon. I don't think we're gonna finish by noon. Good morning, sir. Mr. Parrish, you were arrested for trafficking in amphetamines, trafficking in ecstasy, possession of a controlled substance, Xanax, possession of ketamine, possession of psychedelic mushrooms, psilocybin mushrooms, it should say, and possession of a place for purposes of trafficking in a controlled substance. Your attorney is present. Good morning. Can you state your name, please?
Good morning, Your Honor. Menachem Mayberg on behalf of Mr. Paris.
Good
So
morning.
he's the third roommate and he wasn't home at the time of the execution of the search warrants.
Okay, Mr. Mayberg, any argument?
Yes, Your Honor. We'd argue for the same reason as yesterday that you find no probable cause on the trafficking amounts. Your Honor, these were personal use. There was a warrant actually that was the reason why the officers came, and nothing in the warrant has anything to do with Mr. Paris. And we'd ask you to find and set the same bail conditions as you said yesterday.
So yesterday was a little different because they found different drugs attributed to each defendant, and I believe the cocaine amount was exactly at the threshold amount, and that's why Your Honor found possession with intent rather than the trafficking.
He's not charged with cocaine here. He's charged
No,
with.
he's charged with trafficking in amphetamines and MDMA.
He has a trafficking amount of MDMA. All right, count one, trafficking. So he has Adderall. And
Yes, Your
MDMA. So 28 grams of Adderall. And then how much MDMA? I don't see a lot. 6
No.
plus 2.
It was
It's 8.
plus the other two
Plus
ecstasy.
6 plus 2. I only see 8. All right, count one, the trafficking in the Adderall. You traffic in Adderall?
It's amphetamines.
Oh, and trafficking in amphetamines. Okay, there's probable cause for that charge. $15,000 bond. Count 2 is possession with intent to sell ecstasy.
Your Honor, I would argue that there's no probable cause for that at all.
Based on the weight. Oh, actually, let me give you a break on that one. Count 2, possession of ecstasy,
Thank you.
MDMA. $2,500 bond. Count 3, there's probable cause for possession of Xanax. Count 4, possession of ketamine. It was, he had 2 bags of Xanax pills. It says 20 grams. I don't know the quantity of it.
No, it's not listed there, Your Honor. And we'd ask to find only for possession.
I did. It's only possession, but I was a lower bond. I'll set count 3 at $1,000. Count 4, he has 2 grams of ketamine. I mean, 1 gram of ketamine. I'll do $1,000 count 4 as well. Count 5 is they sell psychedelic mushrooms. It didn't even say psilocybin, ROR.
Thank you, Your
Count
Honor.
6, there's probable cause for possession of a place for purposes of trafficking in a controlled substance. I'll set that, I don't know, $1,000. All right.
Thank you.
No Nebbia. Good luck to you. No Nebbia. You can bond out.
Thank you, Your Honor. Have a good weekend.
It's you better listen to your lawyer. Lawyer, stay in trouble.
Your Honor, what was count 1?
15,000. I'm going to say the bonds again. $15,000 for count 1. Probably really remember. 2,500 count 2, 1,000 count 3, 1,000 count 4, ROR count 5, 1,000 count 6. No Nebbia. Okay.
All right. First of all, we'll take a look here and go over the new SIR 88 and the 145 and the 101. Mr. Wood, have you received a copy of the updated PSI? And if so, do you have any amendments, corrections, or objections to make to the content?
Judge, I have a change to be made to the restitution provision, and I don't think it's in the nature of allocution. I believe it's a change that needs to be made. Paragraph 15 of the recommendations, Your Honor.
Yes, sir.
It simply says you must pay child support and related expenses as ordered by the court. That's a phrase that has been passed down from MDOCs on these cases, so that's what most of the agents say, but it's not as complete as it needs to be. It should say you must pay ongoing child support and arrearages in the amount of $17,096.39. That's the current arrears. And then a sentence after the sentence that's there right now that says ongoing child support and arrearages must be paid through the Wexford County Friend of the Court or the Michigan State Disbursement Unit.
Mr. Van Amel, you make. Thank you. I think we also, and I'll turn back to Mr. Wood in just a second. I think we were originally scheduled back on November 10th, so we have to change the CFJ 145, page 1, which is today's date, which of course is November 24th. All right, Mr. Wood, we're with you. Anything further that you believe needs to be amended or corrected?
Not at this point, Your Honor, no.
All right, thank you. One moment. All right,
Judge,
Mr. Oh,
Judge, I apologize. Again, these are, I think it's a change that needs to be made, not just a allocution, but Judge, the liabilities section near the end of the report says there are no liabilities, and I mean that's all this case
obviously
is
that
about.
does not, yeah. Yes.
His liabilities. So his liabilities are ongoing child support in the amount of $310 per month. And again, a child support arrearage in the amount of $17,096.39. So that's what I would like the liability section to say.
Oh, all right, thank you. Mr. Van Atmel can make that change. Which section are we looking at? Is that back in the old part? Because I don't know
yes,
if we
it is,
covered that. Yeah, it would be back in the previous PSI because the update doesn't deal with that. That would have to be probably CFJ 284. Hold on.
Yes.
Mr. Van Atmel.
Page 10.
All right, there we go. All right. So underneath finances on CFJ 284, page 10 of the previous PSI that was issued back on November 7th of 2004, we're just going to add that there are liabilities. Granted, it's already listed underneath the liability narrative, but we can address that. All right, thank you. All right, Mr. Hartel, any other amendments, corrections, or objections to make to the content of the report?
No, Your Honor.
All right, 1 second. I want to make sure I understood the Killebrew.
The Killebrew was for a delayed sentence, Judge, and
Yep.
he didn't meet the threshold for a reduction, so he's got the 2 counts of felony non-support. There's no Killebrew beyond that as to what we would ask for at this point.
I got it. I'm getting it. All right, thank you very much. So now I'll turn to allocution to the defense. Go ahead, Mr. Hartel.
Thank you, Your Honor. I would ask the court to consider this being a situation where there is no additional jail or probation. I believe that would be appropriate under the circumstances. My client, albeit has not met the threshold to get the benefit of the delay of sentence, but at least some payments were made. He does realize this debt, which is the best way I can think of to describe it, will continue. He will continue to owe the child support and the outstanding court costs. If he fails to do so, well, he'll be staying at the local county lodgings. And he is aware that these don't just go away. People do have arrears into the future. He's also, I'll even use this phrase, painfully aware that he's going to have the label of being a felon as a result of this conviction. Is going to influence him in all the ways that influences everyone else. Finding work was difficult before. It's going to be even more difficult for him. He is not going to be able to do the same level of hunting he used to enjoy, things of that nature. I do believe those punishments and the fact that this will continue to be owed are sufficient without any additional punishment. Thank you, Your Honor.
All right, Mr. Wood, allocution, sir.
Well, Judge, I know the recommendation is for straight probation, and you know, if Mr. Newell had been paying, I know as and it's correct that he's made some payments, but he's missed most months. I mean, since the initial sentencing back in December of last year, his $4,200 bond had already been paid in. And so that's in again, December. He paid nothing, and I understand he's a cement contractor. That's our understanding, is that he has a business and he's only 36 years old. He's an able-bodied man by all accounts. But he paid nothing in January, February, March. In April, he paid $600. He paid nothing in May, nothing in June. In July, in the heart of his season, he paid $1,200, but he paid nothing in August, nothing in September, nothing in October, and nothing so far in November. It's unacceptable, Judge. He's got a 6-year-old child here that he's going to have to take care of for a long time. And he did pay his bond, so he got the benefit of the delayed sentence, but he did not do well during the delay, Judge. I'm thinking, Judge, I'm thinking it's the Monday before Thanksgiving. And I'm thinking that Mr. Newell maybe needs to spend the next period of time that you can choose in the Wexford County Jail. And he needs to be on probation. We're going to ask for 3 years. I know normally I'd ask for 5 years. I don't think that's permissible anymore. I don't know the exact requirements, but 3 years of probation. And again, some initial upfront jail, so he understands that this is serious and he needs to comply with the court's orders. But
can I give him jail on a felony on a felony non-support with an intermediate sanction scoring of 0 to 9 months?
Sure you can, Judge. I mean, he basically committed several felonies while he was on your delayed sentence. Yeah, each month he didn't pay is another felony. And yeah, there's no prohibition. Maybe probation can pipe in about this. No, you can give him upfront jail.
Yeah. So, but what would you suppose my reasonable grounds be?
Because he's committed felonies while he was on a delayed sentence, and he did not comply with the underlying child support order. Judge, I don't think there'd be any problem with you imposing, again, I would suggest 7 days of jail starting now. And, so he doesn't wait till after Thanksgiving. And then again, this is a 6-year-old child that he's got to take care of for a long time, Your Honor.
Let me go back and address one of those comments. What was the felony that he committed while he was on a delay?
Well, Judge, I know it's the felony non-support statute, MCL 750.165 says, so that's the felonies he's committed, Judge. Each month he didn't pay. That's another felony. And again, we don't think of it that way, but yeah.
It was the way you said it. I thought maybe there was a felony that committed that I missed, but there hasn't been any new convictions while he's correct?
No new convictions.
Yeah. So, all right. So on the felony non-support, 1 second. So. Ask a question. 1 second. There we go. Sorry. So what I'm looking for is what are my reasonable grounds that I can use today to go and rebut the reasonable presumption or presumption that he is to get probation and fines and costs only. Is there an exception for that on child support, or because typically there's an exception for crimes that are violent, like domestic violence, assault, battery, and so forth. So that's why I was looking at this concerned. I think it's 771.34, or no, 769.31B. That's what I wanted. Is there an exception to that? 769.31B that should have some exceptions. So I have to have reasonable grounds to be able to give somebody any kind of confinement. And so far as I understand it, underneath that section, I have not allowed to unless there is a certain exception. So that's my problem here.
Judge, I'm looking at 769.31B. Oh, this is 31.
Yeah. And then it's into 34. So 769.34 takes me to where an intermediate sanction must be imposed unless I have reasonable grounds. And I need to know, that's why I'm asking, what are my reasonable grounds? Now, there can be some exceptions here for violent crimes without finding reasonable grounds. But the problem here is it's an intermediate sanction. Those in Lansing have told me, which includes the entire legislature, because it was almost overwhelmingly voted for by everyone back in 2020. I say everyone that held a legislative position and the governor told me that when there's an intermediate sanction, I am not to give jail unless I find reasonable grounds. Now, that makes it troublesome, and sometimes it makes it troublesome for me. And say a child support case, or actually even a variety of cases. Let's say it's an embezzlement from a car dealership. Right. I don't have somebody from a victim coming in and saying, Judge, this is really, really hard because it impacted me because we couldn't pay wages, we couldn't pay salaries. Or here, if I had something, and by the way, I looked, there's no victim impact statement. If the victim had said, hey, I can't afford to pay for soccer games, or I can't afford to feed the child, then I'd have some kind of reasonable grounds. When I look here in the past, I don't see that. I see the defendant has been on, he's had a couple dismissals. I will say he had one case where he had a probation violation back in 2007. So I need to have some reasonable grounds, and I don't really know what they are, especially without a victim like a wife or the mother of the child being here.
I have to be honest with you, Judge. I've done a whole lot of these hearings. This is what when I retired from the division, from the AG's office, I was running this division.
Yeah.
And
trust me, I want to place a parent who is not taking care of their child. But this, I don't know when you were last in charge of this division,
right?
But 769.34 became law back in 2020, took effect on March 24th of 2021. And this law says that when there's an intermediate sanction, such as in this case, I am not allowed to give any jail unless I'm able to find reasonable grounds. Now, when I find reasonable grounds, I can't take into consideration anything that was already used to reach the scoring, which means I can't take in his prior criminal history. I can't take into consideration the amount of money. I can't take into consideration the fact that he's got 2 convictions at the same time, because all those things are taken into consideration for finding reasonable grounds. And personally, I may not like this statute, or how it ties the hands of the court. But so far, it also hasn't been reversed or challenged in the Court of Appeals yet. So I need to know, I'm looking, if is there a separate exception that applies to these kinds of offenses? That's what I really need to know. So,
well, Judge, if the law doesn't allow you to, again, while someone's on a delayed sentence, which is it's a matter of grace from the court, I can ask for it. You don't have to give it. I don't have to ask for it. You can give it anyway. We ask for it. You placed him on the delayed sentence. And then during the delay, he flaunted the court's order. I mean, he again violated the underlying child support order, and he committed, again, I could count them up. I think it's 7 or 8, maybe 8 or 9, because the way the law is written, when this project started a long time ago, back in the early 2010s, the AG tried to get the law modified so that there was a tiered, maybe a $0 to $1,000 in arrears is not a crime yet. Maybe 1 to 5 is a 93-day misdemeanor, 5,000 to 10,000 is a low, high court misdemeanor, that sort of thing. The legislature did not want to do that. Instead, the way the law reads is that each month that a person doesn't pay child support, a day late or a dollar short, is a new crime, is a felony. Yeah. And so he's on a delayed sentence that you placed him on. And during the delay, he commits 7 felonies. And I know he hasn't been convicted, but I don't hear any argument that he did pay. No, I was paying, they just didn't know it.
I got it. So, Mr. Wood, you are preaching to the choir. Here's another thing. Can I give somebody jail when they fail to pay fines and costs on probation?
Again, you have somebody from MDOC sitting there, and I understand that if there, there's a distinction between a technical violation and a non-technical violation.
I know, but if somebody violates by not paying their fines and costs on probation, let's say he wasn't on a delay, am I allowed to put somebody in jail merely when they're unable to pay unless somebody proves to me that he has the ability and chooses not? That's the key language.
Right. I'm familiar with that concept, Judge.
Yeah.
Absolutely.
Yeah. So, yeah. So
now the unique thing about,
go ahead, sir.
The unique thing about these cases is if he doesn't pay his restitution while he's on probation, again, that's a crime. And so, whereas normally not paying restitution, although again, there is still the provision where we've got to show that he does have the ability, or it may be that he's got to show that he doesn't have the ability. That would make more sense. I know we've done some hearings like that.
Yeah, Mr. Wood, I completely agree. Everything you're saying makes so much sense, but the legislature and with the approval of the governor have told me that what you and I think makes sense is the law. There has to be proof that the defendant could afford to pay and chooses not to. Or I have to have reasonable grounds. And when I get to these hearings, by the way, prosecutors rarely ever bring in witnesses to tell me, here are the reasonable grounds, such as not having this money means I couldn't pay for this, I couldn't pay for that. I can tell you, I want to put deadbeat parents in jail. I need to have the legal authority to do so.
Judge, if the victim was there, how does that, where does that, I apologize, Judge, but where does that fit into the, you now have a reasonable basis?
You'll note that I began this conversation, and by the way, I'm doing this intentionally for a couple of reasons. But I first began by asking the question, where is the authority that allows me to do it? And unfortunately, there really isn't. Because 769.34 tells me I can't unless I have reasonable grounds, which means until someone presents something to me that allows me to find reasonable grounds, because there's another court rule, there's another statute here, and I think it's probably the 769.31, where if I find that the guidelines are inadequate, and that's the problem. This is one of those things where whoever enacted the statute may or may not have known what they're doing, but I assume they do. That's what the law tells me. I'm supposed to believe that they do. It says that I can find that the guidelines are inadequate and don't account for it. I could use that for reasonable grounds, but so far it's not presented to me. That's my problem. So, all right, here we go. All right, sir, Mr. Newell, you have the right to make a statement before the court issues a sentence. Is there anything you wish to add today, sir?
Yes, sir.
Yes, sir, go right ahead.
First of all, I apologize for what's going on here, and you know, I've tried the best I could for the whole year on this probation thing. It's just been a struggle for me, you know, and I'd like to, Mr. Woods here said that I paid in July $1,200, and I'd like to, it was $1,250. And each payment that I made was over $500. I understand that I have a $310 payment each month, but I simply couldn't make them. Life's a struggle right now for me, you know. And I'd like to apologize. I'm sorry. Thank you.
All right. Court sentences the defendant as follows. The court places the defendant upon a period of probation for 36 months. I adopt the terms or conditions that are listed in the pre-sentence investigation report on CFJ 145, page 2, continuing on to page 3. That includes the added change to the language on paragraph 15, which is term or condition 9 or 8.9. That is, the defendant is to continue to pay his ongoing child support and paying on the arrears, which are $17,090. I think they were $96.39. The defendant has the right to be considered for early release on probation at halftime if he's been compliant with those terms or conditions. I don't know here whether or not, I think all the terms or conditions are probably appropriate. Let me take a look at this defendant's criminal history. Yeah. The court wants to ensure that the defendant is not using any kind of substances, but the random testing is only if required by by the probation officer. The court is concerned though, because if there is an alcohol or substance use issue, whether it's marijuana or alcohol, the court wants to ensure the defendant is clear-headed so he's not missing it. Now, there's probably one thing here. Hold on, let me go through the fines and costs. So we had $268 state minimum fees, the $130 crime victim right front fee. I'm going to do the $300 court cost. I'm going to keep the fine at 0. The attorney fee again is $300. We probably did not need a DNA fee here. $30 is supervision per month, or $60 if there's any electronic monitoring. The big question here is what, if anything, can the court do for sentencing as far as any jail time? Well, I was looking for the argument. No one was able to provide it. At least nothing that really helps me understand this. How old, what year was the child born in? Does anybody want to tell me? 6 years ago? Yes. All right. So, and is it just one? Yes, okay. So,
Off and on, so work's been slow.
Mr. Wood, I'm going to tell you, these rules and these statutes do not make sense when you, and this is what I'm trying to do today. I'm trying to highlight, at least as part of this three-branch government as a judicial officer, maybe you as part of work, go and deal with this yourself. But I can't use anything because no one's given me anything yet. By the way, if prosecutors were to decide to start showing up and presenting to me some more victim impact statements, maybe I could. So I give the defendant his 15 days in jail with 15 days of credit. Do I think a person who care of the child, should he or she go to jail? Yeah. But the legislature has told me that I can't, unless I have reasonable grounds. And I find that the guidelines are inadequate. So far, I have nothing that's objective. My only decision would have to be subjective. And I can't do that as a judge. That's not within my realm. I'm supposed to be, and I am neutral when I'm sitting here. So anyways, all right, that is the sentence of the court.
The delay, the fine, attorney fee, and court costs were $100. Did you want to increase to 300 or leave them?
No, thank you very much. I'll just leave them because I really want him to be able to pay these fees off. I'm sorry, the child support. Thank you very much, Madam Clerk. So I've adjusted those amounts. All right. Trust me, Mr. Wood, you and I agree.
Well, Judge, I greatly appreciate the time you've taken to go through this process, because this is going to go up the chain of command here. Because I'm a little
perplexed,
say embarrassed that I know there's restrictions, but when someone commits a felony, that should certainly be an exception. And there should be exceptions. So I will look into this, Your Honor, and I greatly appreciate your time. And Mr. Newell should know that what the AG can do is, if he doesn't pay going forward, they can charge him again with felony non-support. If he isn't paying at least his ongoing support, that's a crime, and that's what the AG does in this division. So he needs to start paying his ongoing support at least.
I understand. Again, today, while two people may agree, I'm not a person, I'm a judge. So, Mr. Newell, you are receiving 2 copies of one document. You will place your initials on one copy. Doing so neither elects nor waives any rights. It merely acknowledges receipt of your copy of that document. This document tells you that you have the right to appeal the conviction and sentence in your case, and is typically done by filing what's called a claim of right to appeal. However, when there's a plea, the plea reduces it down to you can only file what's called an application for leave to appeal. If you choose to file an application for leave to appeal, and you want the court to appoint an attorney to assist you, you may complete the bottom half and return to the court within 42 days. Do you understand, sir? All right, Mr. Newell, I know we've been talking around you a lot today. This is about you as a father. You got a kid out there who needs you. Maybe it's just money, I don't know, but let's focus on that. I know you're having a difficult time. I hope that you're taking jobs, even if it's something that's like you might think is below you, because when you're a father, nothing is below you. I don't care if it's picking up trash, working in a Christmas tree field, or picking fruits or vegetables someplace, or working in a yard.
Well, I've applied at a couple jobs recently within the last 2 weeks, just because I know it's get towards winter and it's gonna be no work for me, you know what I mean?
Yeah.
So, just so you know, I'm trying.
Mr. Newell, keep it up. Keep it up. Work hard, okay? Thank you very much. We are adjourned.
Thank you, Your Honor. Thank you, Mr. Artell.
excuse me, Mr. Perkins, I'm seeing you at the same time because your cases are identical for first appearance purposes. What I mean is each of you are accused of violating the terms of your probation or community control. And in each case, the circuit judge assigned no bond warrant. So what I want to do this morning is I want to go ahead and arraign you on these VOP cases and get you an attorney appointed if you're asking for one. Mr. Brand, would you like to have an attorney appointed to represent you?
Yes, sir.
Great. And Mr. Perkins, same question.
Yes, sir.
I'm going to appoint the public defender's office to represent both of you. Listen to Mr. McDaniel. He's going to give you a court date, and then we'll see if you have any questions in just a second. Mr. McDaniel.
We're going to plead not guilty. Yes, to set this on January 8th pretrial docket, and I've advised the most spoke. Mr. Green will come by and visit them prior to that hearing.
Mr. Mitchell, anything?
No, Your Honor.
So January 8th will be your arraignment date, or your not. You've already been arraigned. It'll be your court date in VOP court in front of Judge Garcia. Mr. Brand, do you have any questions?
No, sir.
Wish you the best, sir. Mr. Perkins, do you have any questions? No questions from him, Mr. McDaniel?
No, nothing, Your Honor.
Andrea Merchant. Merchant, good morning. Ms. Merchant, you're here for first appearance, ma'am. You've been accused of one count of theft between $100 and $750, 6 counts of theft, petty theft. These are all retail thefts of less than $100, and 1 count of scheme to defraud. That scheme to defraud is a felony. Ms. Merchant, I did take a look at the dates of these offenses. So what it appears happened is you got arrested and charged, you entered a plea to probation, and that triggered Walmart to go back and look at further videos from the same payment information. Usually it's the same card, same something. Anyway, when they looked at further previous videos, that led to these charges. So this does not violate your probation because these charges all allegedly occurred before you were even on probation. So I'm going to address your bond or your release status in just a moment. Let me hear from the attorneys and see if they have any additional information they want to make sure I'm aware of. Mr. McDaniel, anything on behalf of Ms. Merchant?
You know, just that she's locally, and as far as I know, she's been complying and reporting in at probation. So I don't think she's a flight risk. So we just asked the court to take those things into consideration.
Mr. McDaniel, I'm probably not going to give her a conditional release because of the felony and the number of charges, but she certainly, I'm not going to set her a normal bond. I'm set her something a little lower than that, most likely. What's her position on the cash bond as opposed to a surety bond?
Yeah.
Cash bond, Your Honor.
Mr. Mitchell, objection?
No objection to a cash bond.
Ms. Merchant, I'm going to set your bond at $100 each on the 7 misdemeanors, $250 cash only on all of these on the felony. That makes your total bond be $9,500, excuse me, $950. $950 cash is your bond. Your bond has a condition of no contact with the alleged victim, which in this case is Walmart. You probably already have that condition on your probation. You can't go to any Walmart while the case is pending. Ms. Merchant, lastly, we're going to ask the jail to give you a notice for your court date, which should be January 6th.
Yep.
January 6th should be your court date. And they'll give you that notice after first appearance. Do you have any questions, ma'am?
Wait, I'm sorry, do I have any questions?
Yeah.
Yes, do you have any
No.
questions? All right,
No.
ma'am. You'll get his phone in a few minutes to try to post the bond, okay?
Okay, thank you.
Sir, are you here on behalf of Mr. Nix? Anthony Nix is next. We've had friends or family come in the courtroom, Mr. McDaniel, so that's why I'm taking Mr. Nix next. We'll come back to you in just a second, Mr. Tucker. Mr. Nix in the courtroom, I want him to know who's here. What's your relationship to Anthony? Okay. So, Mr. Anthony Nix, your father's in the courtroom on your behalf. Mr. Nix, you're here because you've been accused of 1 count of domestic battery by strangulation. Mr. Nix, there is probable cause for the charge. I do have a few questions relating to bond conditions or whether you're going to get a bond or not, or you're going to get a bond. The question is whether you're going to get a conditional release or not, a bond or release. Mr. Nix, the information I've got is that you're employed at Rex Lumber. Is that accurate?
Yes, sir.
How long have you been there?
I've been there almost a year.
The only prior record I see is an old pretrial intervention. I don't know how old it was. It was several years ago. but it was for allegedly possessing 2 hydrocodone pills. And that case was eventually dismissed. Is that the only history you have? Criminal
Yes, sir.
history, that is?
Yes, sir.
Let me see if
That's
the
it.
attorneys have any additional information that I need to be aware of then. Mr. McDaniel, anything on behalf of Mr. Nix?
No, we just asked for conditional release.
Mr. Mitchell?
No, nothing for the state, Your Honor.
Mr. Nix, I don't have a problem with the conditional release, given that additional information. I am concerned about the living situation. Did you and she live together?
Yes, sir, we did. I won't be.
And my question is, do you have somewhere else you can go on a temporary basis other than where she lives?
Yes, sir.
Your dad's saying you've got a place with him if you don't have anywhere else. Is that right?
Yep.
Okay.
Yes, sir.
So,
That's fine.
given all of that, what I'm gonna do is let you pick between a bond and a conditional release. I am gonna offer you a conditional release, but everybody that offer a conditional release to, I give them a bond option. Some people prefer a bond. If you like to post a bond, on that charge of domestic battery by strangulation, the bond will be $5,000 cash or surety. But because of your criminal history, I'm going to let you offer you a conditional release. Either way, you'll have a condition of no contact. You'll have the standard conditions of every conditional release plus the condition of no contact. And Mr. Nix, I'll also ask the jail to give you a notice for your court date, which I believe is going to be January 6th at 8:30. So, Mr. Nix, knowing all of that, do you want to accept the conditional release?
Yes, sir.
So let me talk to your father just a second. So, sir, what will happen is they're going to let him get dressed. They'll let him use the phone if he needs to. Then they're going to bring him to the courthouse. The reason for that is so he can meet with Mr. Goodson or Mr. Ham, one of our conditional release officers. That takes 5-10 minutes. And then once he meets with them, he's free to go. Is someone going to be able to pick him up here? So your dad says someone's going to pick you up here. Usually that's 30 to 45 minutes before they'll get him here. Because get him dressed and processed out and everything. So he'll be downstairs in 30 to 45 minutes, Mr. Nix. Mr. Nix at the jail, do you have any questions?
No, sir.
In the courtroom, any questions? Mr. London Nix? All right, wish you the best, sir. I did say no contact. I believe I said it. I know I did. Okay, so back to Mr. Tucker, the state versus James Tucker. Mr. Tucker, good morning. You're here because I don't need it. You need it. Mr. Tucker, you've been accused of one count of possession of controlled substance without a prescription, one count of possession, drug paraphernalia, and one count of driving with no valid driver's license. There is probable cause for those charges. I did note that the controlled substance is allegedly a single pill or tablet. That's what you're accused of. Your criminal history is very bad. That's probably being gracious. So it's really bad. So I'm going to listen to the attorneys, and I'll be glad to set you a reasonable bond. Mr. McDaniel, anything on behalf of Mr. Tucker?
Your Honor, I mean, I think we're just going to ask for a reasonable bond. I think the bigger issue is driving and just, the no valid license. I know we've dealt with him several times, but.
You my lawyer?
I am, but I'm trying to.
Come on, man.
Mr. Mitchell, anything?
Your Honor, we just request a reasonable bond with conditions of random UAs, and I didn't look at his driving history, but if it's significant, we request no driving.
So, Mr. Tucker, I think what Mr. McDaniel was implying is I'm probably, even if you didn't have the felony, I probably would have set you a bond on the other two. I would have. I wouldn't have given you a conditional release even without the felony. So I think he kind of knows how I do things. It's because of your driving record primarily. I think this says it's at least your third no valid, maybe your fifth. It's one or the other. So I'm going to set you 3 misdemeanor bonds. Now, one of them's not a misdemeanor, but I'm setting you a misdemeanor bond because it was a single pill. Okay. So your bond is $2,500 on each count. Your total bond, Mr. Tucker, is $7,500 cash or surety. You have the right to post it. If you go through a bondsman, and if they charge you 10%, it'd be about $750 to get out of jail. Mr. Tucker, you'll get these phone in a few minutes to try to post the bond. They're also going to give you a notice for your next court date, and that would be January 6th at 8:30. Your bond has conditions of random urinalysis and not to drive without a valid driver's license. If you can get a driver's license, drive all you want. But if you get caught driving without a valid driver's license while you're out on bond, that would revoke your bond. Mr. Tucker, do you have any questions, sir?
Yes, sir.
Wish you the best, sir. We have Willie Ruth Pittman.
Your Honor, can we do the Pittmans last, maybe go down to Anthony Hearns?
Sure. Anthony Hearns. Mr. Hearns, good morning. Mr. Hearns, you're here because you've been accused of one count of possession of methamphetamine, one count of possession of drug paraphernalia, and one count of resisting an officer without violence. Mr. Hearns, I did read the complaint. There is probable cause for the charges. I also looked at your criminal history, Mr. Hearns. I think you're entitled to a bond. let me make sure I'm not missing anything that the attorneys want to make sure I'm aware of before I set that bond. Mr. McDaniel, anything on behalf of Mr. Hearns?
No, Your Honor.
Mr. Mitchell?
We just request he be subject to random UAs.
Mr. Hearns, I'm going to set you the normal bonds I would set for these charges, sir. The bond on the methamphetamine is $5,000. The other two misdemeanor bonds would be $2,500. Your total bond, Mr. Hearns, is $10,000. Cash or surety. You do have a condition of random urinalysis on the bond. Mr. Hearns, you will get to use the phone in just a few minutes, sir, to try to post a bond. If you post it, you'll be released. If you're not able to post a bond, the public defender's office will be in contact with you at the jail. Mr. Hearns, also, I'm going to ask the jail to give you a notice for the felony arraignment date, which is January 6th at 8:30. Mr. Hearns, it was your father a Hearns?
Yes, sir.
Which one? Was he one of the Willies?
His mom, no, my father was murdered in Jackson County back in '89 or something like that. But no,
Okay,
Willie
yeah.
Hearns is my brother. Willie
Well, now,
Reed was my brother.
There's more than Willie. There's more than one Willie. There was Willie A, Willie B,
Willie
and Willie
A
C.
and Willie B.
Willie, and
Willie-
I went to
Willie A
school.
and
With,
Willie-
I went to school with. I think Willie B is the one I went to school with at Grand
Yes, sir.
Ridge.
Yes,
So,
sir.
Mr. Hearns, you'll get to use the phone in just a few minutes. Any questions, sir?
No, sir.
Wish you the best, Mr. Hearns.
Thank you.
Mr. Gill, I apologize. I should have already tried to take your case. What case you here on?
I'm actually waiting, but I'm just, I want to make sure that,
You're the one that Mr. McDaniel needs to take last. Okay. Shamari Garrett, Miss Garrett, good morning, ma'am. You're here because you've been accused of one kind of petty theft in case 25262 MM. Miss Garrett, ma'am, there is probable cause in that complaint. I'm appointing the public defender's office to represent you, ma'am. I want to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke with Ms. Garrett in 25262 MM. She's going to accept the PTI offer from the state. It'll be 6 months. She'll take a retail theft class. It'll be restitution of $155.39. She'll have no contact with Walmart. Be a $370 fine. And states agreed not to file MRB 24168, 169, 170. And this will resolve this case this morning.
Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor.
Miss Garrett, did you hear that agreement, ma'am?
Yes, sir.
He didn't say that. You sure? The court costs and fines are $370, Mr. McDaniel?
Correct. Yes.
Okay. Miss Garrett, is that the program do you want to enter that PTI program, ma'am? Do you want to do what your attorney put on the record?
Yes, sir.
Miss Garrett, yeah, I explained to everyone that every PTI comes with a conditional release, and here's why that's important. That gives some teeth to the program. If you violate the PTI, and what that means is if you get caught going to Walmart, was this a Walmart case? Yeah. If you get caught going to Walmart, if you get charged with a new crime, if you don't report in like you're supposed to, if you violate in any substantial and material way, you could go to jail with no bond. That's what the conditional release does. Do you understand all of that?
Yes, sir.
Okay.
No question.
And you still want to participate in the program, right, ma'am?
Yes, sir.
Ms. Garrett, I'm going to show your case referred to the pretrial intervention program for 6 months, 25-262 MM. The conditions will be asked Mr. McDaniel placed on the record, ma'am. Ms. Garrett, try to get everything done early, because if you get everything done early, you very well may get off the probation, or not the probation, the supervision early. Ms. Garrett, at 3 months, at the halfway point, if you got everything done, there's a good chance the probation office, the PTI office will go ahead and send a letter or an email to Mr. Mitchell asking if he wants to dismiss the case early. And normally the state will do that if everyone's done everything they're supposed to. What's going to happen next is they're going to let you use the phone, ma'am. After you use the phone, they're going to bring you to the courthouse, because that's where the PTI office is at. Once you get instructed by the PTI officer, you'll be free to leave. If you do call friends or family, you need to tell them you can be picked up at the courthouse in 30 to 45 minutes. Any questions?
No, sir.
Have a good day, ma'am.
You too.
We've already seen Nick, we've already seen Mr. Perkins. Is Mr. McCardle? Mr. McCardle, good morning. Mr. McCardle, you're here again. We started to resolve your case yesterday, and we had some questions. And Mr. Goodson's back today if needed. So you're here for the charge of violation of county probation in 24-504 CT. I've already appointed Mr. McDaniel's office to represent you. Please listen to Mr. McDaniel.
Your Honor, I spoke with Mr. McCardle in 24504 CT. He's going to admit that he violated his probation. You understand, he'll serve 30 days in the county jail. He'll have 5 days jail credit. And whatever fines and costs that are associated with the case, he'll either work off here in the jail or there'll be a civil judgment.
Is $1,179 on his fine balance, Mr. McDaniel.
Thank you, sir.
Thank you both. Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor.
Mr. McCardle, did you hear that agreement?
Yes, sir.
Mr. McCardle, do you have any questions about that agreement?
No, sir.
Mr. McCardle, is that the admission you would like to enter, sir?
Yes, sir.
Mr. McCardle, I'm going to accept your admission that you violated the terms and conditions of your supervision. In case number 24-504 CT, I'm going to revoke that supervision. I'm going to sentence you as agreed to 30 days in the Jackson County Jail, 5 days credit. Remaining court costs and fines are still owed of $1,179. Mr. McCardle, there's no probation involved in this sentence. You finished those 25 days you have left. It may be less than that under Florida game time law. Hopefully it will be. At most, it's 25 days. But the jail can explain to you the game time laws in Florida. Mr. McCardle, there's no probation involved in this sentence. You finished this jail sentence. This case is over. Any questions, sir?
Judge, would you consider letting him turn himself in Monday morning here at the jail and finish up that jail sentence?
So I could eat one
No.
family?
No.
I mean, I turned
No,
myself in Sunday.
the reason is that I already agreed to change the sentence from 60 to 30, so you could be out for
Okay.
Christmas. So
Yes, sir.
you're going to be out for Christmas, but not Thanksgiving. Now, if you want to go back to 60 days, I'd probably let you
No.
out for Thanksgiving if you
I'm
told me
happy.
Thanksgiving was more for it.
No, sir.
All
I
right.
appreciate you.
Wish you the best, sir. Then we have, which Pittman do you want to take first? Miss Willie Ruth or
Willie
Mr.
Pittman, I
Randall?
guess. Willie Pittman's not in here. Did you get my text message? She's
I
just too
did,
sick
and so this is state of Florida
They're trying
versus
to
Willie
force
Ruth Pittman. This is state of Florida versus Willie Ruth Pittman. She's charged with battery on law enforcement officer. There is a complaint. There is probable cause. And Miss Pittman's unable to attend first appearance this morning, and is due to medical or mental health reasons, Mr. McDaniel.
Yeah, they're trying to force her to eat, I think, and she's having some, just medical issues, and she's not eating, and, they're trying to get her to eat, I think, right now. I think they're just about there being as nice as they can to her, but medical issues and mental health issues.
Mr. Gill, anything from the state?
Judge, we'll defer to the court. We have no objections to proceeding in absentia on a bond analysis. If that's what the court wants to do.
Mr. McDaniel, law enforcement contacted me before making the arrest about whether a warrant, probable cause, and PC questions. Basically, I think they did everything they could within their power to try to find an alternative to this, including attempting to contact state agencies and looking for family members to take Ms. Pittman. And the other defendant, my other Mr. Pittman, recently checked her out of a facility that it took months and months to get her in. So there was no one to care for her. So I think this was kind of a option of last resort. They couldn't leave her alone. So there's certainly probable cause for a crime. I'm gonna set her a bond today, a $500 cash bond. But I'm glad to see her at any point to review that if and when she's able to come to first appearance, Mr. McDaniel. But for today's purposes, she's going to have a bond of $500 cash, and we'll see where it goes from there. It took months in circuit court to get her in the program last time, I believe. Yeah.
All that work is probably undone.
Yeah, they wouldn't accept her back. So that takes care of her first appearance. That brings us to Mr. Randall Pittman. So Mr. Randall Pittman, come on up, please. Mr. Randall Pittman, good morning. Mr. Pittman, you've been accused of one count of, the first appearance sheet says intent or threat to do violence. I'm assuming it's an assault allegation once I read the complaint. That's the assault statute they're using. So you've been accused of one count of misdemeanor assault. And I've been advised through a text this morning, a text to Mr. Mitchell and myself from Mr. McDaniel, that you do not want an attorney appointed to represent you for first appearance purposes. Is that correct?
That's correct, Your Honor.
Okay. So I don't know if I've ever had that at first appearance. Do I have to go through the same analysis for first appearance purposes as I would for representation?
Judge, I don't think I've ever seen that either.
But I think it is each stage of the proceeding that you have to inform him of his pro se rights.
Okay. So you have the right to an attorney. That's the best thing to do, especially if you don't have any legal background or legal training. But if
I
you
do,
want to
Your Honor. Can
represent
I explain
yourself,
to you?
you're going to have to let me talk. That's one thing attorneys
Okay.
do is they let the judge talk and then you'll get a chance. We take turns. That's kind of how it goes. So I've got to ask you some questions to see if, about your educational background and your desire to represent yourself. And I've got to stress to you the importance of why that may be a bad idea. So tell me about your educational background, Mr. Pittman.
I went to Cottondale High School.
Okay, any college?
Initially, and then I got transferred over to Gracefield High School.
Any college?
I have a bachelor's degree. My brother and I received scholarships at Marshall University, football scholarships.
Okay.
I played
Mr.
football.
Pittman, what is your bachelor's degree in some kind of legal studies or something totally different?
My degree is in business administration.
Okay.
And,
Mr. Pittman, did you have any postgraduate work? Did you work towards a master's or anything?
Well, I've been working undercover for the state of California for about 20 years as an attorney general.
Mr. Pittman, as an attorney general?
And that's a sad point for Jackson County because they didn't know that. But I had to reveal that now because I'm in court.
Mr. Pittman, have you ever been to law school?
I've been going up and up. I'm sorry.
Have you ever been to law school?
I'm sorry.
I need you to listen to my questions, Mr. Pittman. I'm asking you specific questions for a specific reason. Have you ever been to law school?
No, I've never been to law school.
Okay, so here's what you got to understand. Mr. McDaniel has been to law school, an accredited law school. He's graduated from that law school, and then after that, he took and passed the Florida bar. And after that, he's been practicing law, Mr. McDaniel, in excess of 20 years. Is that right?
Correct.
So here's the thing. This is what I heard a judge explain it to me one time, and explain it to a defendant, and I was in the courtroom. You're about to enter a process, and the way the judge described it, you're about to have surgery. And what you're saying is that even though there's a surgeon here next to me who's willing to do the surgery, and that's his job, I don't want to do that. I want to go ahead and do surgery on myself. That's essentially the analogy that I'm using for you representing yourself. In other words, it's a bad idea. Knowing that, you still want to waive your right to an attorney and represent yourself for first appearance purposes.
Your Honor, I promise you, I'm the best attorney in the nation. I promise you that. So
do
I'm
you want to
willing...
represent yourself for first appearance
Yes,
purposes?
I do. Yes, I do.
All right. So do you want to be heard on the issue of probable cause?
Yes, I do.
Go ahead, please.
First of all, Your Honor, this was really a bad decision by the sheriff's department. Enfield, he's the one who he tells these guys to do this every time to me and my mom. He's already told me, I don't care where you take your mom, but you need to get her out of Jackson County. So that's why all this stuff keeps happening. It's called Enfield. And honestly, Judge Garcia, she's a good and fair judge, but she is being controlled by Enfield. That's why all this stuff is going on.
Your Honor, we're going to. All right. So, Mr. Pittman, that's nothing to do with probable cause. That's just you rambling. So I'm not going to listen to any more of that. Mr. Pittman, before you elected not to use him, Mr. McDaniel sent a text this morning to Mr. Mitchell and myself questioning whether there was probable cause in your case. And his question was that it appears to be a conditional threat, and conditional threats typically cannot qualify as assault because the assault statute says the threat must be imminent. That's the key word in this particular analysis. Mr. Mitchell, any position on, or Mr. Gill, either one of you, on whether or not this meets the basis for probable cause for assault?
Judge, it does appear to be a conditional type of analysis. We would ask for 24 hours to amend. There could be facts that were not put in the probable cause affidavit to establish a charge for assault.
Okay, thank you, Mr. Gill. So the complaint says that you allegedly went to where those two people were at, and that may be considered an overt act, which may have a basis or a part of the analysis to determine whether or not there's assault or another crime. So what I'm going to do is I'm going to determine there's no probable cause for assault. But based upon your criminal history, as well as the recent mental health history that the record reflects,
I have no criminal history,
in the other
Your Honor.
case,
I have zero criminal history. I have zero criminal history.
You do have criminal history. You've been arrested within the last few months for a case involving your mother, correct?
They were all dropped. All those charges have been dropped. Did you not hear?
Fair enough, fair enough. They were dismissed. You were arrested, but not dismissed. They're still part of your history. They're just not convictions. I'm going to hold you for 24 hours. I'm going to see you tomorrow morning. If they haven't amended the complaint to include probable cause, then I have to release you. That's the law. It's very clear. If they have amended the complaint, then what's going to happen is I will see if the amended complaint includes probable cause for a crime. If it does, I'll set you an appropriate bond or consider other release options. So I will see you in the morning.
You're not gonna give me bond today?
You're not getting a bond today because there's no probable cause for a crime. Now, if you want to waive the argument of no probable cause, since you're representing yourself, and agree that there's probable cause or stipulate that you're not contesting that, then I can set you a bond today. Otherwise, I can't set you a bond.
Yes, I'll do that. I need a bond today.
So you want to stipulate only for first appearance purposes that there's. Okay, you want to stipulate for first appearance purposes. Well, your mom's going to be in jail, and you're going to have contact with your mom. I'm fixing to do a no contact order once I find probable cause based upon the history.
You got to be kidding me.
Absolutely going to do no contact. That is absolutely going to happen. You're going to have no contact with your mother because I think you're a danger to her. So my question for you is, do you want to waive any objection to probable cause so that I can set you a bond, or you want me to see you tomorrow and see if they can establish probable cause?
Yes, I want the bond.
Okay. Mr. Gill, you'd like to be heard on the bond.
Judge, we'd just be asking for a reasonable bond, and we would be asking for no contact with Willie Ruth Pittman.
Your bond's $5,000 cash or surety with a condition, no contact with your mother. To me, that is an absolute necessity to ensure her well-being. You have the right to use the phone to post the bond, sir. If you post the bond, you'll be released. Any questions, Mr. Pittman? Court date. January 5th court date. If you give him that notice, please, that would be at 9 a.m. You'll get his phone in just a few minutes, sir, okay? Have a good day.
Sir.
Your Honor. Good morning. P 30758 yes, Mr. Nunez. Your Honor, the time set for arraignment pretrial in this particular matter. As to the pretrial, you would stand mute to, as to the arraignment, you would stand mute to the charges, waive a formal of those charges, and ask for the plea of not guilty.
All right, here in the court will waive the formal reading, enter plea of not guilty for purpose of the arraignment. As to the pretrial.
As to the pretrial, Your Honor, at this time, it's my understanding that in return for a plea responsible to, to a double parking, as well as to a expired plate, the original charges will be dismissed. Constitutional rights. He understands those constitutional rights, wishes to enter into this plea opportunity, and there are no immigration issues.
All right, sir, please raise your right hand. The other right hand. The other right hand, thank you. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
And you heard the plea that was placed on the record, correct?
Yes.
As to the amended charge of double parking, how do you plead?
Responsible.
Okay, you may already, yeah, thank you. As to the amended charge of expired plate, how do you plead?
Responsible.
You've gone over your advice of rights with your attorney, correct?
Correct.
And you understand all of those rights?
Correct.
And you also understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency. And knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
All right, the court will accept the plea as knowing and voluntary. It's $200 for double parking, $100 for the expired plate, and the original charges will be dismissed. That's a total of $300. Do you have that to pay today, sir?
Yes, I'll pay him for it.
All right, please stop at the window. Somebody will be with you shortly.
Thank you, Your Honor.
Have a good day. Thank you.
Thank you.
And we are on the record in the matter of the city of Wyandotte versus Nicole Weems, 251269.
Morning, Your Honor.
Good morning.
Your Honor, John Goldblatt, P 30758, on behalf of Ms. Weems. Ms. Weems, please put your name on the record.
Weems. Okay, Ms. Weems, you're on probation with this court.
Yes.
And yet, here you are. Counsel, as to the arraignment.
Your Honor, as to the arraignment, she stand mute to the charge, waiver form reading of those charges, ask that a plea of not guilty be entered on her behalf.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and as to the pretrial.
As to the pretrial, Your Honor, I've had an opportunity to discuss this matter with Ms. Williams. I've also discussed with her the fact that she is on probation and that this would have an adverse effect, entering into some sort of a plea, with respect to that. But knowing all of that, she wishes to avail herself of the plea that's reached. My understanding that he will, in return for a plea of guilty to operating while impaired, the people would move to dismiss the original charge of operating while intoxicated by BAC. Explain to her constitutional rights and explain to her the rights that she would be waiving by entering into this plea agreement. He wishes to avail herself of this opportunity, and she doesn't understand those constitutional rights. Is that correct, Ms. Williams?
Yes.
And there are no immigration issues.
Please raise your right hand, ma'am. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
And you've gone over your advice and rights with your attorney, correct?
Yes.
As to the amended charge of operating while visibly impaired, how do you plead?
Guilty.
You've gone, and you understand the rights that you've gone over with your attorney, correct?
Yes.
And you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
You do understand, ma'am, that this is likely going to trigger a probation violation, correct?
Yes.
And knowing all of that, do you want to continue with your plea?
Yes.
I can't hear you.
Yes, I'm sorry.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues? I'm sorry?
No.
Counsel, if you can please pardon your client.
You, Ms. Williams, on August 25th of 2025, you were operating a motor vehicle in the city of Wyandotte.
Yes.
And there come a point in time where you came into contact with some Wyandotte police officers.
Yes.
And prior to coming into contact with those Wyandotte police officers, were you consuming alcohol?
Yes.
And
Ma'am, you need to keep your volume up, okay, please?
and what were you drinking?
I had a bit of bourbon.
You had a bit of bourbon.
Yes.
Would you state you had quite a bit of bourbon?
Yeah.
Okay. And when you were seen by the police officers, they gave you some certain field sobriety tests. Is that correct?
Yes.
And eventually you were detained and you took a PBT as well as a breathalyzer test. Is that correct?
Yes.
And the results of that breathalyzer test were 0.1
.184.
and 184. Is that correct?
Yes.
Okay, yeah, thank you, Your Honor. Defense is satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will accept your plea, your very generous plea that you were provided, ma'am, and dismiss the original charge per the plea agreement as to bond counsel.
As to bond, Your Honor, Ms. Williams has complied. She's appeared here today. She's gainfully employed. As the court is well aware, she is on probation to this court. This was obviously when we spoke to her. When I spoke to her, I informed her that this would be a violation of that probation. She understood that. She told me, when I questioned her, what was going through your mind, she said it was just a real bad day and that made it worse. So I'm just indicating that to the court. I'm asking that she's accepted responsibility for this incident as well as a probation violation by entering into this plea at this point in time. We're asking for a personal bond as she gets ready to go for sentencing.
So ma'am, you had a lot of real bad days, it appears, in this court, because your matters date back all the way to 2022. And 23. failed to display a license, allowing an unlicensed driver to drive. That was as a result of a driving while license suspended. Another driving while license suspended, plate violation, possession of paraphernalia, which is what you're currently on probation for, and now you have a high BAC.
Okay.
You're not allowed to drink alcohol on probation anyway, ma'am.
Okay.
Yet you did it anyway. Well, we're gonna test right now what's in your system. When's the last time you consumed any alcohol?
That night.
Where do you work?
Right now, I just got a new job at, it's called Baker's Life. It's a life insurance agency.
Well, given the fact that you're on probation for possession of paraphernalia, and you've completely disregarded the conditions and orders of this court for probation purposes, the court has concerns that you're going to disregard its orders of bond. To ensure that you're not going to do that, the court's going to order a $5,000 10% bond. You're not to possess or consume any alcohol or drugs unless prescribed, which you're already not allowed to do because you're on probation. And then you are not to be released without an alcohol tether through the Wayne County Jail.
Your Honor, can she able to post it, make arrangements, rather than going to Wayne County Jail to obtain the tether
Yeah.
here, if that can be posted? Instead of through the Wayne County Jail, the tether.
There's no talking in court. If you want to have a conversation, go out into the lobby, sir. No, your client's being taken into custody. She's not going to be released until she has the Wayne County Jail alcohol tether.
Thank you.
So you're going through this door today, ma'am. You want to have a conversation with your work that you won't be there.
She's released you, then what's that too? Wait. It's time to speak today.
Okay, ma'am, you can step out into the lobby because you and your person next to you continue to talk. That's why you're out in the lobby. Counsel, I indicated that your client's taking the ride down to Wayne County Jail to get the tether.
I understand, Your Honor.
Yes.
And then when she's released on the tether, she will then have to appear for.
Oh, for a PSI, yes.
What I was.
I'm sorry, I didn't understand
what you were saying about going to Wayne County. Yeah.
Yes.
Just confirming what she's to do once she.
Yes. Yes.
Okay. Thank you, Your Honor.
All right, thank you. Have a good day. We're on the record in the matter of the city of Wyandotte versus Jamie Singleton, 2540. All right, and counsel?
Your Honor, John Goldthwait, P 30758 on behalf of the city. Please put your name on the record.
Okay, and so good morning. Today is the date scheduled for the pretrial. Your client had previously failed to appear in June. Then a warrant was issued. She ended up in custody in November. And the court had arraigned her November 12th. set today's date for a pretrial and your client posted the $2,500 10% bond.
That's correct, Your Honor. Your Honor, I have had an opportunity to discuss this matter with Ms. Singleton. I've also had an opportunity to discuss with her the reasons why she's on an alcohol debit. I'm not an alcohol debit, on out of another matter. As a detainer, as a witness detainer. That proceeding is scheduled for some time in December 1st. I have discussed it.
Which court is that in?
Pardon?
36th district.
Okay.
I'm sorry, Your Honor. And so as of today, she's already pled on the not guilty. This is a pre-trial. I've discussed this matter with the prosecutor. It's my understanding that Ms. Singleton would plead guilty to the charge of drug paraphernalia with the understanding that there is a recommendation and only a recommendation of time served plus costs and fines in this particular matter. With that said, Your Honor, she wishes to avail herself of this plea opportunity.
Please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And you heard the plea that was placed on the record, correct? As to the charge of possession of drug paraphernalia, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct? You understand all of those rights?
Yeah.
Are you picking her up, Ally?
Yeah.
Okay. And you also understand by entering into a plea that you'll be waiving some of those rights. You also understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency. You understand the recommendation is for fines and costs only and credit for time served, but that's only a recommendation.
Yes.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
And counsel, if you can please order your client.
Thank you. Ms. Singleton, back on April 7th of 2025, were you in an automobile with a Mr. I'm sorry, Cosmo?
Yes.
And there was a traffic stop.
Yes.
He was the driver of the car.
Yes.
Is that correct?
Yes.
And during the traffic stop, one of the police officers talked to you, and at one point in time asked you to step out of the vehicle. Is that correct?
Yes.
And you did step out?
Yes.
And then they asked if they could search you. Is that correct?
Yes.
And you consented to that search.
Yes.
Is that correct? And during that search, they found Chore Boy and drug paraphernalia on you. Is that correct? And you knew that you were not supposed to possess drug paraphernalia. Is that correct?
I was unaware of them embarking.
But you did
Yes.
possess it.
Yes, I did.
Defense is satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the charge and counsel as to sentencing.
As the sentencing, Your Honor, I would ask for, she did do 8 days. 8 days on this particular matter. Subsequently to this case, she does have some prior contacts. I don't believe that there are any drug contacts, so there may be paraphernalia or something, but there's no drugs. We're asking for costs and fines in this particular matter. She can move along, go be a witness against somebody in the 36th District Court.
Ma'am, if you're to test right now, what's in your system? When's your next date? Your next court date, December 1st?
Yes, ma'am. I'm having Jim meeting at 7.
Okay, now Carlos Cosme is here. Is he any relation to Jose?
He's, no.
Just happened to
I
be
don't
here.
know him.
Okay.
Oh,
That's probably weird.
Oh, okay, yeah.
Yeah, no. He was the driver of the car. He paid my bond. I don't know if that has anything to do with it.
Carlos?
No.
no,
Jose.
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 Jose. Oh, I'm sorry.
$100 fine, $100 cost, crime victim assessment fee of $75, justice system assessment fee of $50, which is a total of $325, is a $50 probation warrant fee. So that total is $375. The court's going to also order, when did you post bond, ma'am?
I think it was like a week ago. I'm not sure what date it was. I don't know.
Well, how do I know how much time to give her credit for, counsel?
What date it was, I'm not sure. I don't remember my date or what date.
Well, you should have probably brought that so I can give appropriate.
When did you get out of Wayne County Jail?
I'm not sure. I think it was like a week, 2 weeks ago. I don't remember the date.
Ma'am, do you not keep track of dates or days?
Well, yeah, I think it was on a Friday.
A Friday.
I think it was, yes, the one.
So would that have been this past Friday?
2 Fridays ago.
Excuse me. This past Friday of November 21st or the prior Friday of November 14th?
November 14th.
So then your client was only in custody for 2 days. On this case anyway, she may have been in custody on another case, but she was arraigned November 12th.
Okay.
Okay,
So I'll give her credit for 2 days.
thank you.
I did have a bunch of cases.
Right, so I'm not giving you credit for all those other days.
Thank you.
Do you have that to pay today, ma'am?
No, ma'am.
I think there was,
Where do you work?
there was a bond posted in her name, Your Honor.
Yeah.
No, I think Mr. Cosme posted it.
I don't have a job, ma'am.
Well, how do you support yourself, ma'am?
I have the easy one helping me, my boyfriend.
How do you support yourself? When's the last time you worked?
It's been a couple of years.
Why don't you work?
I haven't.
Well, obviously,
Yeah.
why don't you have a job?
I don't think.
Well, look, because I'm giving you 45 days to get this paid.
Yes, ma'am.
Friday, January 16th. Paid in full.
Thank you.
Thank you.
You have a good day. We're on the record and then, oh, no, Mr. Westmoreland's everywhere.
Sorry, Your Honor.
She has a question for you.
Oh. Go to the front window and I'll tell you how to fix it.
We're on the record, the matter of the city of Wyandotte versus Tawana Buckner, 251299 AB.
Morning, Your Honor.
Good morning.
Your Honor, John Goldpaw, P 30758 on behalf of Ms. Buckner. Ms. Buckner, please put your name on the record.
Okay, good morning, and please keep your hands out of your pockets. And today's date scheduled for the arraignment and pretrial in this matter. And counsel?
As to the arraignment, Your Honor, as you state. No, those charges asked for a plea of not guilty be entered.
All right, the court will waive the formal reading, enter plea of not guilty for purposes of the arraignment. As to the pretrial, counsel.
As to the pretrial, Your Honor, I discussed this matter with Ms. Buckner as well as with the prosecuting attorney. Like saying that in return for plea of guilty to no operator's license on possession and responsible to the expired plates that the driving while license suspended as well as no proof of being responsible to no proof of insurance. I may have said expired plates, but it means that the driving while license suspended, the no insurance, and the expired plate. Explain to her constitutional rights. She understands those constitutional rights and understands that by into this plea, she'd be waiving some of those constitutional rights. Knowing all of that, she wishes to avail herself of this plea opportunity, and there are no immigration issues.
Okay, I'm going to please raise your right hand. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay, are you picking our valley? I need you to speak up louder, please.
Yes.
Very good, thank you. And you heard the plea that your attorney placed on the record, correct?
Yes.
As to the amended charge of no operator's license on person, how do you plead?
Responsible.
No, that was going to be,
No operators is good.
Yes.
okay. As to the amended charge of no proof of insurance, how do you plead?
Yeah. Responsible.
And you've gone over your advice and rights with your attorney, correct?
Yes, ma'am.
And you understand all those rights.
Yes, ma'am.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, ma'am.
You've gone, you understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, ma'am.
Knowing all of that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
And counsel?
Thank you. Ms. Buckner, on September 3rd of 2025, were you operating a motor vehicle in the city of Wyandotte?
Yes,
Did there come a point in time when you came in contact with the Wyandotte Police Department?
yes,
When they asked you to provide them with a valid driver's license, you were unable to do so, is that correct?
correct.
So you could not have a valid operator's license on your possession at the time you were operating this motor vehicle. Is that right? That's satisfactory.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will accept your plea to the amended charge, dismiss the original charges per the plea agreement. And ask to sentencing counsel.
That's the sentencing, Your Honor. We'd ask for immediate sentencing in this particular matter. Ms. Buckner has one more matter to take care of. It's in some place in God's country. Attica, Michigan. She's been in contact with them.
Yes.
Is trying to set up a plan to get that matter set aside or solved so she can have her full and complete life. She was driving this day. She borrowed somebody else's car because she had to get her 4-year-old son to get to a dentist appointment that she had for quite some time. She clearly understands this within the state. She's gainfully employed. She's single. She has 4 children.
Okay. So, ma'am, how'd you get here to court today?
I Ubered.
How much of that set you back?
Like $38.
And she's been here early, Your Honor, so
Yeah.
I understand. She's the only one that's being called early today, I'm gonna guess.
I understand, and right, I'm just saying that because she wants to get this and we get responsible.
And how do you get back and forth to work, ma'am?
I Uber or I ride with one of my coworkers if we're on the same schedule.
And how do your kids get to and from school?
They get on the school bus.
All right, and how, do you owe money up in Attica? You already know how much you owe? You have to go up to court.
No, I made a court date with him. I didn't contact them. I had to go up there to the court and then they had to do my facts and things that day.
Okay. All right, so the court's going to order a $100 fine, $100 cost, crime victim assessment fee of $75, justice system assessment fee of $50 on count on the no ops. So that's $325. And then you have the no proof of insurance is $175 for a total of, it looks to be $500 even. How much can you pay per month? And what day of the month works best for you?
My pay is bi-weekly, so I would say maybe $100.
Okay,
Okay,
and when can you begin that?
I get paid on Friday this week, so starting Friday this week.
Okay, beginning December 5th?
Yes.
Okay, if you'd like to stop at the window and get information about paying online, you can certainly do that. Okay?
thank you very much.
All right, good luck to you, ma'am.
Thank you.
Have a good day.
Here's a lot more influence.
We now call 22-39417, the state of Texas versus Jacoby Damon Broussard. You, Mr. Broussard?
Yes, sir.
Present with your attorney, Mr. Adams, and the state's attorney.
Yes, sir.
Earlier, you entered a plea of guilty to the first-degree felony of murder in this case. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it? State?
I've reviewed it. I have no objections or changes, Judge.
And defense. Then without objection, it's made a part of the record for all purposes here. The agreement is whatever sentence shall not exceed a cap of 30 years imprisonment. So we really are looking at no less than 5, no more than 30 years confinement in prison. I believe there aren't any other options, correct?
Correct, Judge.
Is that the way you understand it, Langston?
Yes, sir.
All right. State, want to go first and last?
I'd like to go last, Judge.
You can go first and last. You can defer. Mr. Adams, go ahead on behalf of Mr. Broussard.
Judge, if you look at page one of the pre-sentence investigative report, and I'm looking right above defendant's version, you'll see that it was 3 people that was all charged with murder: Jacoby Rousseau, Arthur Small, Charles Moss, and they all were charged with murder. Prior to today, it's my understanding that Arthur Small and Charles Moss has already pled before your court, Judge. And Mr. Helm can correct me if I'm wrong, but I understand that Mr. Small got 8 years, and at that time, Mr. Small was already on probation in your court for another case. And then I believe Mr. Moss, and Mr. Helm can correct me if I'm wrong, I understand he ended up pleading for, I believe, 15 years, 20 years, 15 years, I believe. So what I'm asking, Judge, is if you look, and I'm only looking at page one. When you look on page one, Judge, you see specifically where Mr. Thomas was shot at the canal, and then he apparently had got into a fist fight, and I'm reading specifically where it says when he witnessed the fight between Thomas and Trey Moss. Trey Moss was the one who was already in your court, and I believe he took a 15-year deal. He is the one that got into the physical fight with the deceased in this case. And then apparently the deceased came back and there was gunshots. Judge, the thing that we would add to the PSI, and Mr. Ham has already provided this to my office, was the forensic post-mortem examination. And I do not believe Mr. Ham is going to contest that according to Judge, what I was going to tell you is according to the forensic exam, the deceased had a gunshot wound through the right thigh. So he took a bullet to the right thigh. And also it says it was another bullet to the left side of his abdomen. And that's in this report, Judge. Here you go, Judge. I'm just showing that he was shot twice. One to the thigh and then one to his abdomen. Okay. So our position. Copy of this. Yeah. Yeah. So our position, I can make a copy. You can have it. Got it. Oh, so what I'm saying, Judge, is that there were 2 shooters, and we believe to make in line with what my client said, where he said in the defendant's version of what happened.
How many times was the complainant, the victim, shot?
Well, we know he was shot twice because he was
At least
because one was to the thigh, and that's what I'm looking at right there, and the other one was to the abdomen. So we believe that there was 2 shooters, and with the 2 shooters, and that's revealed, and there was 2 wounds, and I was letting you see where I got that from. It's our position that the wound to the abdomen came from Mr. Moss, and then apparently the wound to the thigh would have been my client, Mr. Broussard. And Judge, if you look specifically, and I'm raising.
Why do you say that?
Because
how can you determine that not being present?
No.
And not having any other scientific evidence to support that other than
because he was there.
Okay, it's what he's telling you.
Right, because he was there, because he saw everything. He would have been there. And Judge, what I'm saying.
So what is it you're saying his responsibility was? What did he do?
Well, I'm saying with there being with the victim being shot twice, I think, hey, he's a party to the offense. But what I was asking, Judge, is that when you look specifically to his criminal history, unlike Arthur Small was on probation when this happened, and he agreed to be a witness for the state to testify against my client. And then unlike Mr. Moss, who's the one that's actually having a physical confrontation with the city, it wasn't my client. And I'm asking if you just read from the PSI, the guy who's the instigator of all of this is Mr. Moss. He's the one that's beating up the man and having a physical fight with him. And he's the one that has more incentive to shoot him than anybody because he got to fight. And our position is that you had 2 shooters, and that and having 2 shooters, my client is culpable for firing a shot, but the one who is the most culpable is Mr. Moss. And again, like I said, Mr. Ham can correct me, but I thought, if I'm not mistaken, he received 15 years. I could be wrong, it might be 20, but I know it was not 30 years. And what I'm asking the court is, Judge, is that if the man who we believe is the most culpable got 15, or I know it was no more than 20, then I don't believe my client should get the max out 30 years. And the reason I'm concerned about that is that, Judge, if you look on page 2, I see where the mother went in there said that she wanted him to get 40 to 50 years in prison, and the dad felt that he should get more than 30. But in my opinion, Judge, in arguing on behalf of my client, the person that was most culpable was Mr. Moss, and Mr. Moss did not get a 30-year sentence. And since he didn't get a 30-year sentence, it's not going to be fair for my client to get hit with 30 years when the man who was most culpable was not. And that's why I showed you, Judge, that it was at least 2. There's no doubt, according to the autopsy report, it's no doubt he was hit twice. There's absolutely no doubt about that. One to the thigh and one to the abdomen. And I think that my guy is responsible for the thigh, but he's not responsible for the one that went to the abdomen.
No, you've seen the pre-sentence report.
Yes.
He's not responsible for anything.
No, I didn't say that.
That's what he says here.
Okay, but
he didn't shoot anybody.
No, I hate, and I
So,
think that,
but you're saying he did shoot somebody.
I think that he needs to clarify that. Yeah, he needs to clarify that.
Oh, he does?
Right.
Well, he was pretty clear here in that when he pleaded guilty, which was odd, but then he later admits he didn't shoot anybody. That's his inference here. But you're saying he did, even though you weren't there.
You know, I wasn't that, Judge, but the thing is, like I said, and the reason why I brought that to your attention, just looking at the autopsy report, to suggest that there was 2 wounds, and there's no doubt about that.
I'm not surprised. I'm looking at what all this says. It appears as though 2 people did shoot. That's why 2 people apparently pleaded guilty.
Right, and it's actually 3 people charged.
But the pre-sentence report, he's trying to play both sides. I'm guilty, but I'm really not guilty. He can't figure out which one he is, Mr. Dr. Jekyll or Mr. Hyde.
And
that's kind of a problem.
That's why I was trying to reconcile his statements with the objective data.
How do you reconcile he didn't shoot anybody who's pleading guilty and he wants to accept responsibility? How does that work? How does it work?
No, I think that he's going to accept responsibility for firing.
But that's not what he says here. When he had a chance, he pleaded guilty under oath, but when he went to talk to the probation office, he changed direction. I mean, being truthful and forthcoming is important. Do you know what happened here? A human being died. A human being, one of God's creatures. You had responsibility with that as well as the other person. But you killed somebody. You feel anything bad about that?
Yes, sir, I do.
Oh, do you? You certainly weren't forthright here to the probation office. You want to just interrupt me?
No, sir.
That's the way you are, isn't it?
No, sir.
I get the feeling you like to control the situation, like you controlled this shooter. You seem to be the boss.
No, sir.
Well, that's the way it looks.
No, sir, you're the boss, sir.
Well, no, that's the way, and that's not the way this pre-sentence report appears. You want to play both sides. I want to make a deal, but I didn't do it. Can't have it.
No, sir.
I'm gonna let you talk in just a second. I want what Dave have to say.
You ready, Judge?
Yeah, go ahead.
Let me address some of the statements by defense counsel so that we can get on the right page. Mr. Small pled to a lesser included offense of manslaughter and received 8 years TDC. That was all part and parcel of an agreement for him to testify against Mr. Broussard. He stated at the time of this incident and reaffirmed during.
You feel, by the way, you feel like that is fair and appropriate under the circumstances?
Yes, sir.
Go ahead.
He's stated early on and then reaffirmed during trial preparation that Jacoby Broussard is the only person that shot Christopher Thomas on that date. There was a 4th person that was there, just and all this is a part of discovery. That individual's name is Ladarius, and he's Ladarius Lofton, and he's been cooperating since the incident occurred. He was one of the 4 individuals in the car, and thanks to him, he came forward whenever this body was found and told the Port Arthur Police Department about the fact that this young man was actually killed. Up until that time, they had not seen the bullet wounds in the body. The body was found in the ditch, but they mistakenly believed that it was some kind of an overdose. Had Mr. Lofton not stepped forward, we never would have gotten to the point where a murder investigation would have proceeded. He was not charged. He was present at the time, and he says again that it was Jacoby Broussard that was the shooter in this incident. So that's an uncharged individual out of this incident, and the reasons why. Arthur Small was not on probation, as defense counsel said. His agreement is based upon his cooperation. The other defendant, Charles Moss, only entered a plea after Mr. Broussard accepted responsibility. He did that on November 13th. He is waiting sentencing. His agreement was a lesser included offense of a manslaughter. Now, this all goes back to, and the whole reason why we're here talking about a cap of 30 for this individual is that factually, Mr. Adams did get one thing right. There were 2 wounds. There's nothing I can prove that there were 2 shooters. There was, we have firearms reports, and the experts were ready to come forward to show that the 2 wounds that occurred on this came from one gun, not from separate guns. So we know that fits with what the other 2 witnesses were prepared to testify. That puts a responsibility on this man for killing Christopher Thomas on that day. There's no doubt that the facts are that Mr. Moss was involved in the situation. There was a fight between Mr. Moss and Mr. Thomas prior to the incident, but there's no evidence other than this man's suggestion that Charles Moss was a shooter. And I agree with Your Honor, as you always do, you honed in on the fact that he wasn't accepting responsibility. He really hasn't done it today. His lawyer has. He stated emphatically in the PSI report that he was there, but he didn't do it, that it was Charles Moss, shifting the blame over to him. The only thing that's good about that is that him making those kind of statements led to Moss accepting responsibility afterwards. But it doesn't step away from the fact of he killed a man. He killed a man that day. He left him there in a ditch, half closed, shot in 2 different spots, and he's the one that's responsible for it. His parents are hurting. You can read that. Their wounds and their emotions just come out on the pages where you read what their responses are to this. I've dealt with this family from the very beginning of this incident when it first got indicted, and we learned that unfortunately Mr. Adams represented the decedent before this offense occurred. This family has never been satisfied with how the system has worked in this regard. They did approve the agreement that I made, but it was very reluctant, as you can tell by their statements here. I have no doubt as I stand before the court that the man responsible for the death of Christopher Thomas is right before you. He pulled the trigger. It resulted in the 2 wounds. The 2 wounds is what caused that death. The concession to bring it down to 30, as opposed to the cold-hearted killing that it was, has a lot to do with all those facts I was just going through. There was a lot that was going to get muddy at the time of trial. There was going to be blaming on other individuals instead of accepting responsibility. I thought I had it worked out to where that was going to occur. And then we get his statements here. That being said, nothing has changed. The facts of the case, which are that Mr. Thomas was shot 2 times with the same weapon in order for it to occur, as defense suggests, there would have had to have been some exchange between Mr. Broussard and Mr. Moss so that one shoots and then the other turns around and shoot. Is that possible? Yeah, it's possible. But it doesn't change the fact that this is the individual that two witnesses says killed that man and left him for dead in the ditch. 30 years is what's appropriate.
Judge, one part that Mr. Ham was leaving obvious is that witness, Mr. Small, has made multiple statements. When he first was approached and gave an interview, he said one thing. Then later on in the case, when the DA's office investigated, he says another thing. My only point is that Judge Moss, as Mr. Ham stated, has entered into a plea agreement. He's saying it's coming back for sentencing. It wasn't a 30-year cap on Mr. Moss. And what I'm saying, Judge, is by way of extrapolation and by way of deduction, when you read the first page of the PSI, it was Moss who had a physical fight with this deceased guy. It was Moss that was the one that was throwing blows with him, punching him. That was Moss. And the deceased came back. So if out of everybody there, the guy, in my opinion, that would have been the most heated, the most angry, is going to be the one who had the physical fight. And what I was trying to say, Judge, and that's why I kept pointing out about the two wounds, one to the leg and one to the stomach. You had two shooters, and that Mr. Moss is going to leave out of here with what, 15 years or something on the cap that he made for Mr. Moss. What I'm saying is that my client should not get 30 when, if you look at his criminal history, to my understanding, Judge, when you look on the last page, he doesn't have that criminal history at all. At all. He does not. And he did go to Memorial High School. He has had employment. And I think, like you said, Judge, it's best for me to, let him do more talking than me. But all I was trying to get the court to see is that there were two shooters based upon the wounds, one to the thigh and one to the stomach. Now, I guess the question for you today is do you accept responsibility for the wound to the leg?
Yes, sir. Take for responsibility. Yeah, they know.
And with that, he's taking. So what I want to do, Judge, is to correct and amend the PSI, because what he is saying is what I said.
Does that kill the man? The wound to the leg?
Well, I think that when you if two people
did that kill the man?
I
take it from your silence, you don't have any answer to that. Yeah. Well, the pre-sentence report, are there any objections to the pre-sentence report?
No, I'm not going to object.
Then it's made a part of the record for all purposes. According to the authorities that investigated this case, they disagree with you.
Yes, sir.
It is determined that Jacoby decided to fire shots at Thomas, striking him multiple times. After he shot Thomas, they left the scene. And then the next morning is when the deceased's body was found in the canal, left to die.
Yes, sir.
And really, both folks who did the shooting here, the defendant and the other co-defendant, have much culpability since they acted together. The just heinous nature of just leaving this person just to die and walking off as though they had a big meal and were going somewhere to watch a ball game or something. It just flippant. To treat a human being like that is disturbing, and to change stories through this pre-sentence report, you are not guilty, and then, but you are guilty, trying to figure a way to manipulate through this without being held responsible. But the investigators who were close to this case and investigated it believed otherwise. Both of you have pleaded guilty. Both of you are responsible for the death of this human being. And the family members are upset that even this limit of 30 years imprisonment just does not seem fair to them. One, the mother states he should get at least 40 to 50 years in prison. None of them called 911. None of them rendered aid to my son. And he was left there to die. And then to be found later the next day. The father of the deceased, he shot my son, made a choice to do that. He should get more than 30 years. But that is not the maximum. And he is disappointed that, as both of them, that you're not being held for more responsibility to taking their son's life, which was a tragic thing here. Anything else to add by anything?
No, I was just asking, just since the other guy who was the fighter get a cap deal that was less than the 30 years, and as to my understanding, that cap was around 15. In comparability to what I'm saying is that I would ask for my clients to be somewhere around that 15 to 20 years as well.
Through investigation, again, the authorities think otherwise about the responsibility of your client. It is determined that Jacoby decided to fire shots at Thomas, striking him multiple times. That's what they think from their investigation. You weren't there, I wasn't there, but the investigators put this together. He pleaded guilty, the other guy pleaded guilty. There's both responsible. Anything else?
I see what you're saying.
Mr. Bruce, anything else you want to add?
I apologize. I'll take full responsibility.
How do you take the life back?
Sure, I wish I can.
Yeah, well, do you think an apology makes a difference to that family?
I sure, and I want to apologize to the family. It didn't happen. It shouldn't happen.
They don't, I guess they're going to, there's not much they can do about it, but they want their child back. Can you do that?
Sure.
You shouldn't have taken it away from another human being. It's not, it was our creator who created it, like created you. You have no right to take it away. You understand?
Yes, sir.
You have to pay a price. You pleaded guilty in this case voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in the plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first degree felony of murder. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 30 years. The judgment shall reflect that a deadly weapon, namely a firearm, was used in the commission of this offense. It will be rendered on the judgment. You will be given credit for all time you have served and a direct relationship to this case. This is the sentence. This is what's fair and just. Unfortunately, I just wish there was something in the law we could figure out how we could bring life back. But it is forever when it's taken away, and you were responsible. That is all.